All persons having business before the Honorable Associate Judges, now presiding of the District of Columbia Court of Appeals. Draw near and give your attention. God save the United States and this honorable court. This honorable session, please come to order.
Good morning, everyone. Welcome to this remote session of the District of Columbia Court of Appeals. We have three matters on which we'll hear argument today. And the first one is number 19 CM 0113 in Re Thomas Chang and Ms. Hughes, when you're ready. Thank you.
Thank you. I've actually, in the interim of this case, changed my name from Christina Matheson Hughes to Christina Matheson. So,
all right. You know, I was just noticing that and wondering whether I had called the wrong name. So thank you.
No, yep, right person. I apologize for confusion on my end. And if possible, I would like to reserve 2 minutes for rebuttal.
Thank you. And you pronounce your name Matheson? Is that correct?
Matheson. Mm-hmm.
Thank you.
And I'm here on behalf of Thomas Chang. This is a case about intent and whether a confused defendant can be found to willfully disobey a court order. The defense began their trial by pointing out that when Christina Tamaro obtained a CPO against Mr. Chang, he was thrown into a new, scary, and confusing process.
Let me interrupt you just for a moment. I'm hearing an echo in the background. Could, I don't know, Ms. Shepard, could you be on mute, please? And I guess I might ask the other judges to be on mute too until they're ready to speak, and maybe that'll solve the problem. Thanks. All right, Ms. Matheson, go on, please.
Sure. So Mr. Chang was thrown into a new and scary and confusing process. He has never been exposed to the criminal system before. The story behind this case actually begins in 2012 when Christina Tamaro, the petitioner in this case, was a manager at Target. And Mr. Chang worked under Ms. Tamaro during some point during 2012. He reached out to her again through social media in 2014 and again in 2017, trying to get her help in obtaining a different job. His outreach turned somewhat amorous. It seemed that he had a crush on her. That was not returned. And eventually Ms. Tamaro filed a CPO to keep Mr. Chang from continuing to reach out to her through social media. There was a trial and a default order for the CPO was entered in December 2017. The CPO was served on Mr. Chang in January 2018, but he signed the wrong year. So it was modified in February 2018. And then Mr. Chang filed a CPO against Ms. Tamaro in March 2018. I'm very sorry, I apologize. Very sorry.
I'm waiting for my dog to bark, so it's okay.
Very sorry.
Can I ask you about procedural history? The trial judge mentions these various iterations of the CPO in December and January and February, but we were given the transcript of the March hearing, and it seems like the CPO that Ms. Tamaro had against your client was modified in March. And we don't have that CPO, and it seems like that CPO, which would have been the operative CPO for conduct that occurred subsequent in July, was not introduced as evidence at the trial. So I'm a little confused that the trial judge seemed to convict him based on violating the February CPO, but my understanding is there was a superseding CPO in March.
Yes, you are correct that the March hearing was to modify that CPO. I have only seen the CPO that you are referencing, the one that was signed in February. And it mentions that he's not, it's sort of standard CPO language that he's not to threaten, stalk, harass Ms. Tomorrow. And then it lists 3 additional witnesses, Matthew Diedrich, Nina Sabaro, and person. But you are correct. It was modified so as to include, my understanding was based on the hearing, so that he could not do outreach through social media specifically. But
So the modification in March did what to modify the CPO?
my understanding based on the hearing was that it was modified to prevent Mr. Chang from using social media specifically to reach out to Ms. Tomorrow or any of her contacts. So he could not send messages to people who were Facebook, that kind of thing.
Is there any indication that the March modification changed the language of the pre-existing CPO with respect to the words harassing or harass or a form of it, and stalk, which were words that the trial court focused on in finding guilt here?
No, I do not believe so. But again, I've not seen the modified order, but I do not believe it adjusted those specific terms.
So
And-
you don't understand there to be a problem. I mean, one might argue a modified CPO supersedes the CPOs before it, in which case, if there's no evidence of the operative CPO introduced at trial, the government's case is fundamentally deficient. Alternatively, one could argue that these CPOs kind of aggregate, which seems to be how the trial judge was thinking about it, because she kept referencing the collection of CPOs that had been issued. In which case, maybe if, the material terms were not changed from February to March, then it doesn't matter that the CPO from March was not introduced into evidence. But
I understand what you're saying, and I agree that one of the elements that the government needs to show is that there was an order, and in this case, we have a modified order, so the terms of that order. And then the other 2 elements are that they need to show that the order was violated and that the violation was willful. The focus of Mr. Chang's defense up to this point has been whether that violation was willful, but you're absolutely correct. One of the very first element that they need to show and prove beyond a reasonable doubt is that there is an order that was violated.
I'm looking now at the exhibit list, and I just want to make sure I understand. There are 2 exhibits that appear to have been admitted that relate to CPOs, and there's one that's called the default CPO, and then that's exhibit 1, and then exhibit 3 is the modified CPO. Is the exhibit number 3 kind of the first modified CPO, not the one that was modified after the March hearing?
I believe exhibit 3 is the one that was modified in February because of
That's what I thought. I just wanted to, that's what I thought. I just want to make sure, because it doesn't have a date. I just wanted to make sure that's my impression, but I want to see if your impression was the same. Thank you.
I apologize. I'm trying to pull that up, but I believe that that's correct. I believe it's just the February.
Please go ahead with your argument, Ms. Matheson.
Okay, I'm sorry. I was trying to look at that. I will.
Right. Oh, I'm sorry. I thought you were waiting for Judge McLeese. I couldn't tell that you were looking at your screen.
Sorry.
If you want to look at your screen and finish answering the question, that's fine.
No, I believe my answer. I believe my answer is correct, but I will double check while Ms. Shepherd is going through her argument. I will double check and look at those exhibits and respond in my rebuttal to be certain. But yes, the the focus of Mr. Chang's argument thus far has been whether his conduct was willful. And to find that something is willful, we need to show that Mr. Chang acted with a wrongful state of mind. And in this case, they're confused in that March 2018 hearing. And it's very, very clear that those excerpts in the brief for your review, it's very clear that he does not understand that his CPO against Ms. Tomorrow has been denied. He understands at that point that he has to stay away from Ms. Tomorrow, but he does not understand that the CPO of Chang versus Tomorrow has been denied at that point.
Well, the trial court found the opposite and concluded or inferred, I guess, that in fact your client is an intelligent person who had an obsession, that he knew what he was doing, that he was clever in trying to kind of circumvent the restrictions that had been imposed by the CPO. And so our review of that kind of factual determination is going to be pretty deferential. What if you were pointing to the transcript in March, of the March hearing, to the place where you would say, look, any reasonable fact finder who looks at that can reach no conclusion other than that your client did not understand that the CPO had been denied. Where do you think that is so obvious as to be beyond reasonable debate in that transcript?
So I would point to where repeatedly the court is asking Mr. Chang to define the romantic relationship and the romantic nature, and he's telling the court to look at W-2 forms. Repeatedly, Mr. Chang says, "I don't quite understand." He says things like, "I'm not following." So he's explaining to the court, and I think I've got the page numbers in the brief itself. I tried to include some of that colloquy. He's talking about trying to email some of the witnesses and not really understanding that we're talking about one CPO versus a different CPO. So if you kind of look at pages of that March hearing, pages looks like 4, 8, 10. The court is telling on page 18 to 19, the court is telling Mr. Chang, you've got to focus on what I'm saying to you. Do you understand me? And Mr. Chang is just not tracking. He's just not following. And when we look to the transcripts of his voicemails to the U.S. Attorney Office later in August, that follows that misunderstanding, where it's very clear that he is reaching out to them to try to prosecute his own CPO against Ms. Tomorrow, not understanding that CPO has been dismissed. And so I would look at the March transcript, and I understand that this court needs to be deferential to the trial court, but we don't have to follow it blindly. This court does have the ability to find that there was error. And in this case, I think that the actions, both Mr. Chang's statements in March and then his actions the following summer, demonstrate that misunderstanding.
Well, I mean, I'm looking at page 18. This appears to discuss the modification of the CPO that we don't have, because it's talking about the provision of not contacting anyone, friends or family, regarding the petitioner, right? And I think that the February CPO had a no contact provision with Ms. Tomorrow herself, and then said you can't contact friends or family through social media, full stop, right? And it was modified in March to say, look, you can communicate with them, you just can't communicate with them about her. And I was wondering how that interacts with your notice argument, right? That he doesn't know. I thought your notice argument, separate and apart from his state of mind and confusion, which I, tend to think that the court didn't credit. I thought his argument was nothing in this CPO tells me I can't go to the police. Nothing tells me I can't contact the prosecutors. And in fact, there's a no contact provision with friends and family regarding her, but there's no provision about contacting law enforcement about her.
Exactly. And trial counsel really tried to address this during the trial and talk about how Mr. Chang was trying to avail himself to the public agency. The police are there to serve and protect, and that he is really unsure of where to go to prosecute. And again,
Can I ask you, does that argument depend on crediting your client's view that he thought he had a CPO so that he could have possibly thought that Ms. Tomorrow had violated it? And let me put the question to you this way. Assume that your client, assume a CPO that said no harassing, has that word in it, whatever other words it might have. And assume that your client had never sought a CPO, and so couldn't even arguably reasonably have thought he had one, and assume that he started making false reports to the police and to prosecutors that he had a CPO that Ms. Tomorrow was violating, and assume that the police started contacting Ms. Tomorrow and she was very upset by all that. So assume all of that. Are you saying that your client, in order telling your client not to harass, would not have given adequate notice that you can't, intentionally, falsely accuse the person who has a CPO against you of violating a non-existent CPO? Or do you think that a reasonable person would understand that that's a form of harassment?
Sorry, we've lost your sound.
is that better? Can you hear me now?
Yes.
Sorry. Having a rough morning. I understand your question, Judge McLeese, but it does, you did enumerate a number of assumptions. I think the case does not hinge on his believing that there's a CPO, although in this case, it is very, very clear that he does believe that he had a CPO and he was trying to prosecute it.
Can you explain? I get the second half of your answer, but the first part where you think it doesn't hinge on that, could you explain to me what would your argument be that somebody who is subject to a no harassment CPO and who falsely accuses the person from whom he's not supposed to harass of crimes that they didn't commit, and that ends up upsetting the person who he's supposed to not be harassing? What would the argument be that that's not harassing, or that he wouldn't have adequate notice that that was harassing?
Well, I would think in that particular circumstance, one, I do not think that applies here, but should that have been the case, there should be, the police should be able to research whether there is an active CPO, whether they're supposed to be enforcing this, that kind of thing. And so it should not extend to where they're actually contacting Ms. Tomorrow.
That's actually an argument that it isn't harassing, which I didn't recall from your brief. And I assume if it's not harassing, then obviously a fortiori you can't have notice that it would be, because it isn't. So you couldn't have had notice that it would be. That seems a little bit like the argument that was made in the trial court about a kind of a right to petition and the like, which was not presented in this court. Are you trying to kind of bring that argument up, that even if your client knew that there was that he had no CPO and he was doing this for malicious reasons to circumvent, intentionally to circumvent the CPO and to torment Ms. Tomorrow. You're saying we should conclude that that's not contempt relative to that order.
That's correct. I did not address this in the briefing because I was specifically addressing this scenario where Mr. Chang believed that he was prosecuting a CPO. His CPO against Tomorrow. If you take away that assumption, then I think you do have to rest on the argument that trial counsel made, that a person needs to be able to avail themselves to these public agencies, public forums, and that he would not. We also need to believe in those procedural safeguards that exist in those forums, that the person's not going to be harassed.
And do you think that, we normally don't decide issues that haven't been briefed on appeal. And this seems like it would be one of them. So do you think that issue is not in front of us? Or do you think that even though it isn't briefed, we should decide it? Or what's your position kind of on the procedural complication raised by your acknowledgement that this wasn't briefed in this court?
I apologize for the oversight on my part. Again, I am operating. I'm trying to convey to the court what the reality is for my client, Mr. Chang, and even at trial, the government conceded that he is operating in an altered reality, and is one that we all acknowledge does not exist. But at the same time, he did not understand, did not exist. And so I think to take away that assumption is error, is the error in this case. I think that
Counsel, I'm sorry to cut you off. You do argue on page 11 of your brief that neither the court nor the CPO itself informed Mr. Chang that he was forbidden from contacting professionals affiliated with the CPO process for the purpose of prosecuting a second CPO. I didn't understand this argument to be waived or to be abandoned. I thought it was right there in the second paragraph of page 11 in your brief. It's not fully, maybe you could have gone on for pages and pages, but you make the argument, which is the same as the argument that the trial.
I appreciate your memory. Your memory is better than mine. I've obviously reviewed the briefs, but have been focused on my primary argument, which is the intent. And so I appreciate your remembering that aspect.
In answer to one of Judge McLeese's questions, you said that doesn't apply here. And what I understood you to say was what didn't apply was his reference to contacting an AUSA or the police and that knowledge about that or learning about that upsetting the complainant. Is that what you meant when you said it doesn't apply here? And if that's what you meant, are you saying there's no evidence that Ms. Tomorrow learned about these things and was upset by them? Or did I just misunderstand your answer?
Judge Thompson, you are correct that Ms. Tomorrow did not, Mr. Chang reached out to police, but I do not believe police then reached out to Ms. Tomorrow. So she only learned of this through her counsel as sort of the trial unfolded and the proceedings unfolded. But I was actually referring specifically to Judge McLeese's assumption that Mr. Chang, we have to set aside whether Mr. Chang believed that he had a CPO against Ms. Tomorrow. And I was saying that does not apply in this case.
I see.
And just to try to clarify,
is it your
what you did or didn't argue?
understanding that the guilty verdict was based solely upon Mr. Chang's actions in reaching out to the AUSAs and the police? Was there anything else? I was trying to recall the date of the incident in which the police went to Ms. Tomorrow's house to serve something, and Mr. Chang, according to the testimony, accompanied them and was standing outside her house. You can correct me if I have that wrong, but do you recall when that occurred? And was that a basis for the guilty verdict, or could it have been?
Yes, I believe the guilty verdict was based on the outreach to police and on the outreach to the AUSA's office. The outreach to the police was in July 2018, and the outreach to the prosecutor's office was in August 2018.
And do you remember the date of the incident that I described?
I believe it is July 2nd. I'm double-
And was his presence outside her house, was that a violation of the CPO?
So Mr. Chang was not there to harass or threaten Ms. Tomorrow. He was there in an effort to prosecute his own CPO. He continued to maintain the appropriate distance. I believe it was 100 yards. And so, no, I do not believe it violated the terms of the CPO. He was not acting, again, he was not acting with that wrongful intent.
Did the government argue this incident that Judge Thompson is referring to in closing?
No, the government did not argue this in detail. They talked about his calling police, but they did not talk about his being in the front yard in their closing.
So, okay.
I apologize again for the background noise. I have a
That's quite all right, Ms. Matheson. You are out of time. Unless there are further questions right now, we'll give you some additional time on rebuttal.
thank you.
And we'll hear from Ms. Shepherd now. Thank you.
Good morning, Your Honors. Janice Shepherd on behalf of the government, the appellee. This court should reject the appellant's arguments because, number one,
I'm having difficulty hearing you, Ms. Shepherd. I don't know if there's anything you can do to adjust your microphone.
Hello? Is that
Yes.
better? Is that
That
better?
is it.
Better.
Okay. Okay, this court should reject appellant's arguments because, number one, the CPO clearly prohibited Mr. Chang from indirect contact with Ms. Tamara.
So can I stop you right there, Ms. Shepherd, and say which CPO?
We're talking, the court found that he violated the January CPO as amended by the February CPO.
Right,
Which is,
but we have the transcript. We were given in the joint appendix, the transcript from the March hearing, which clearly indicates that the CPO is modified. And usually there's a piece of paper that is then generated that is given to the defendant that says, okay, now here are the terms of the CPO that you are now operating under, that are now restricting your conduct. And to show that a defendant committed contempt of court by violating those terms, generally, that's the order that you need to put into evidence. So is there a problem that the March CPO itself is not introduced into evidence at the trial in this case?
I don't believe that it is, to the extent that the March modification was a modification based upon motions filed by Mr. Chang and trying to adjust the type of communications that he could have with the Miss Tamara's friends, family, and associates on social media.
But Ms. Shepherd, the government bears the burden of proof at a criminal contempt proceeding, and we literally don't know what the March CPO looks like. I mean, maybe it looks exactly like the February CPO with just a little extra language typed in, but maybe not. I mean, mistakes happen, and you know, we have no idea what the March CPO said. All we know is that we don't have it.
Well, to the extent that this court doesn't have it and it wasn't admitted in trial, and there was no objection to the fact that anyone was operating under the wrong CPO, we would say that that was that there was no any error by not submitting it into evidence was not plain was plain error, and that there was no objections made.
So
Do we
So
actually know that there was generated a piece of paper called the March modified CPO?
From the
Or might it be the case that there is a February one as modified by the transcript of the March hearing? I just don't know. Do you know?
No, I don't. That is not in the record. The only CPOs that are in the records are CPOs one, the exhibits 1, 2, and 3.
well, we know that in March there is a proceeding where the CPO is modified as a result.
But
And Mr. Chang, you would concede Mr. Chang has to be given notice of those modifications. Are you arguing that those modifications could just be made orally and he could continue, he would be on notice of whatever the CPO terms were by virtue of the written February order and oral modifications that were not memorialized in a March CPO?
based upon the record, it is not clear whether or not an actual written modification was handed out or distributed. However, the modifications were motion based upon motions made by Mr. Chang to make some adjustments to his contacts and how he could contact Ms. Tamara's friends, relatives, and social media contacts. And that seems to have been the gist of any modification to the original order, or to the last order, I should say.
I just want to make sure I understand. The government's position is it didn't have an obligation to put that if there was, well, the government does not know if a written CPO was generated after the March hearing. Is that correct?
That's not quite correct. The government may know at some point, but that is not in the record here. So I cannot make a representation that the government does not know.
Okay. But the government's position is it doesn't matter that if a new order was generated, that it wasn't put into evidence at the trial, even though the elements of the violation of a CPO are of contempt, the elements of a contempt conviction are violation of an order that is willful, but you don't have to put the actual operative order in. Is that the government's position?
The government's position is that if that order in March did not terminate or change the fundamental basics of the original order, I will say the January order as
don't know whether it changed is the point.
I'm sorry.
You said if it didn't change it, but we don't have it, so we don't know.
There was no contention or claim in the trial court or to the trial judge that in fact the order that the judge was operating on and finding the violation was no longer in effect, and therefore he did not violate that order. That argument did not come up before the trial court.
Okay. So we're going to pretend like the February order is the operative order, is the bottom line of the government.
The February order as amending the January order, which is what the trial judge was operating under, the January order as amended by the February order.
Well, I would assume you would concede at least that to the extent the March hearing indicated an intent to modify the order, or maybe did orally modify the order, that if you were trying to prosecute Mr. Chang for violating something that was written in the February or January orders, but that seemed to have been revised based on the transcript of the March hearing, that you'd have a problem, wouldn't you? Or do you actually think that it would be fine to prosecute him for something that violated the February and March orders, January and February orders, but seemed to have been revised based on the oral discussion in the March hearing?
If I understand the question correctly, yes, the government would have a problem if they were prosecuting Mr. Chang for violating the January-February orders when on a provision or a term which had been modified by that March order.
So it seems like, to the extent you said that we should treat this as though it's okay to prosecute based on the February or the January order as modified by the February order, it seems as though what you just said means the January order as modified by the February order and as modified to the extent we can know that based on the March hearing. I mean, it seems like you're acknowledging that the March hearing modified the order and you couldn't prosecute Mr. Chang in a way that was contrary to those modifications. So you need to include the March order as orally modified, or as we might infer that it exists, or I'm not sure what, but it does seem like you're acknowledging that people need to take account of what appears to have been a modification of the March order.
The March order on the transcript on page 17 to 18 indicated that the transcript indicates that the only change was a minor modification of adding regarding the petitioner, which was discussing with her friends and family and social media contacts. He could contact them, but he could not contact them regarding the petitioner.
I get your point, your argument that it's a minor modification that's reflected, but I just was trying to make sure that everyone was agreeing, because it originally seemed like you weren't, that a prosecution of Mr. Chang for violating a CPO has to be consistent with the order as modified in March.
Yes, and the government wouldn't be prosecuting him for something that had been modified or changed or deleted from the two orders the operative orders.
Right.
And in fact, the
government
guilty verdict in this case was not based on anything having to do with social media communications. Is that correct?
That is absolutely correct.
But the government bears the burden of demonstrating what the March order as modified said. And I want to go back to the page 12 of the March transcript, which I think pretty clearly indicates that a written order was generated. And there's a question, Mr. Cooper, I don't know whether he's representing the government. I think he's representing the government. Is there a copy available for us, Your Honor, of the agreement that we're hoping to sign? Yes, sir. Can you print one out? Deputy clerk says, sure. The court says, thanks. And then they're talking about printing it out. So it seems like a written order was generated from that proceeding, and it just was never introduced into evidence at the contempt trial, which seems problematic.
The March order any March order was not admitted into trial. That's correct. And the agreement, the parties apparently was speaking about an agreement that the parties had come to in terms of how it should be, how the the CPO should limit Mr. Chang's contact with Miss Tamara's social media contacts.
Okay, but I mean, down at the page at bottom of 13, anything else on this second modified civil protection order that was provided to me? Presumably, that's the court asking, presumably provided for the court's signature, right? Because courts sign off on these things. So it seems like there was a written order. And I won't belabor the point. Can we move on? I mean, I guess we have to assume what the terms in under your argument, we have to assume what the terms of the order were, and we assume that they, in material respects, mirrored the terms of the February order. And can you tell me why the government thinks that Mr. Chang violated the February order, those terms?
The government's position and the court's finding was that Mr. Chang violated the order by conduct of making indirect contact with Miss Tamara through...
So, indirect contact. And that's where you have me. What he does is he contacts the police and he contacts the prosecutor, right?
Yes.
So say I have a CPO against, or Judge McLeese has a CPO against me, and I'm not allowed to contact him or harass him. But I I am able to fill out some sort of form from the MPD website saying that he has done me wrong, that I want to file a police report against him. And then I try to upload that document to get it to the police. And say the police get it, but the file is corrupted, they can't read it. Have I indirectly contacted Judge McLeese or harassed him?
If I understand the question, the contact didn't go through correctly, but
I get onto the police website, I fill out their paperwork, I submit it to them, but because of some technical glitch, they can't read what I've submitted. And now I want to know, have I violated the CPO that Judge McLeese has against me, saying no contact, no harassment?
Technically, it would be a violation, but
what do you mean technically?
Technically, the language, the terms of the CPO is that you cannot have direct or indirect contact with.
Where does it say indirect?
I'm sorry.
Where does it say indirect?
Where does in the CPO? The CPO provides that Mr. Chang may not contact Ms. Tamara by telephone, writing, electric, or social media in any other manner, either directly or indirectly through a third party. That is on page 2 of the CPO.
So, but how have I indirectly contacted Judge McLeese through a third party in my hypothetical?
In your hypothetical, if it was clear from whatever the contact was, I know you said that it had been corrupted, but apparently it went through in some sort of a way. But once you make a contact with the police or in this case, Judge McLeese, when you're prohibited from contacting him through a third party, once you make the contact to the police asking for the police to,
But that's not, I guess my question, that's only a contact with the police.
but
That's
the,
not a contact indirectly with Judge McLeese, right? If I had contacted the police and said, here's my report, and they had downloaded it and then contacted Judge McLeese, I would agree with you that that's indirect contact with Judge McLeese because the contact is made. But here in my hypothetical, I reach out to the police and then it stops because in my hypothetical, the file is corrupted. So I'm trying to figure out, where is the contact? There's contact with the police. Where's the contact with Judge McLeese?
the contact is with police, and when you make a contact to the police, the act of contacting the police to file a report against Judge McLeese, you are making that contact so that the police can have contact with Judge McLeese.
Well, that's
And
certainly
that would
one
be-
thing that we can do, but there's nothing in this order that says I can't contact the police. What it says is I can't indirectly contact Judge McLeese, and I haven't done that in my hypothetical.
Except that you have taken actions to make contact with Judge McLeese.
No question. I mean,
So-
if I write a letter to Judge McLeese and mail it, but I don't put postage on it and it is returned to me, have I made direct or indirect contact with Judge McLeese? I did it. I wrote the letter, I posted it. It came straight back to me. Have I made contact, direct or indirect?
In that scenario, it does not appear that you have made contact. But in the hypo that you have presented with making contact to the police, when you make that contact, the contact is with the intent that the police contact Judge McLeese.
In my first hypothetical, I just contacted the U.S. Postal Service with the intent to contact Judge McLeese. So what's the difference? You said in the mailing of the letter, there's no contact, but in the contacting the police, there is. I don't see a distinction between the two.
When you look
And I
at
don't see a distinction with the facts of this case where I go to the police and the police say, that's very nice. Thank you very much, and show me the door, and don't reach out to Judge McLeese at all.
When you look at this court's decision in N. Ray Sobin, this court where there was a indirect contact where the respondent was found, the defendant was found guilty of indirect contact with his son who had a CPO against his father. This court did not get into any of discussion of whether or not that contact, giving messages to the son or a flyer to the son, whether or not the son actually ever received it. It was
But the person who was contacted was the son's lawyer, right? So someone who had an agency relationship with the son, or fiduciary relationship.
The person that he contacted was indeed the son's lawyer, but not for the CPO case. It was for a completely different case. Therefore, even though it was the son's lawyer, this court did not consider whether or not that lawyer actually delivered these messages to Mr. Sobin's son.
Ms.
But
Shepard, can I ask you, we've been talking a lot about indirect contact, and I wanted to ask you about a different concept that appeared in the trial court's ruling, which is stalking. Do the January and February CPOs prohibit stalking?
Yes, they do.
And When the trial court returned its verdict, did it refer to stalking as as a way in which the trial court refers to intent to harass and intent to indirectly contact? But I think the trial court also refers to the idea of stalking in returning its verdict. You know if that's correct?
Yes, it did. That is correct.
And do you know what do you know about how stalking works with respect to some of the questions that have been asked about whether the efforts to harass have to be communicated to the intended victim?
With stalking, it has to be some sort of repeated action towards the intended victim.
Right, and the trial court found two here. The contacts with, well, I guess maybe three contacts with the police officer, and then separate contacts with the two AUSAs.
Yes, and the trial court found that Mr. Chang was looking for creative ways of trying to reach out to Miss Tamara and circumvent the language of the order. The order was clear and specific that he was not to have direct or indirect contact. And by contacting the police and the prosecutors, asking for her arrest and prosecution, what more could he have thought other than that the police would try to make contact, even if she wasn't going to be arrested or prosecuted?
So you're going, Ms. Shepard, you're going back to contact, but Judge McLeese is asking about stalking, and the government's brief in passing says, and also this was harassment and stalking, but your brief really does seem to be focused on contact. I didn't see any case law or any analysis of stalking in your brief.
The government did not, it's not included in the brief because that was not the issue in the appeal brief, and we were responding to the issues that had been presented on appeal. However, in the trial court, the trial attorney had submitted case law supporting that this type of conduct would be harassing and stalking.
But just to be clear, Mr. Chang's brief says, look, I'm making a notice argument. There's nothing in the CPO that says I can't contact the police or the prosecutors. And so, the government could come back and say, no, but there is language in the CPO that says you can't contact Ms. Tomorrow, and this was impermissible. This was definitely impermissible contact. And I see that argument in the government's brief. And the government could also argue this was also stalking and harassment, and the government could support those arguments. I don't see those arguments supported in the government's brief. It seems like the government was going all in on this was impermissible contact.
Yes, the government's brief basically is saying, in response to the appellant's brief, that this was impermissible contact and that he had noticed that it was impermissible contact because in CPOs, there are explicit and implicit. So it is explicit that he cannot contact her indirectly. Implicitly, that also means he cannot, although he can contact the police and the prosecutor's office for any number of legitimate reasons, he could not contact them to make illegitimate use of the police to make contact with Ms. Tamara.
This is my last question, but just based on what you said that there's law about CPOs having implicit implications. I thought our case law was pretty clear that the terms of CPOs had to be specific, definite, clear, unambiguous. What case are you relying on for the implicit implications of a CPO?
I do not have the case at hand, but if I can submit it, I will submit it after the oral argument. However, to the extent that he was on notice that he could not have direct or indirect contact, and he knew that he did not have a CPO. I know I'm out of time, but going to the question of, did he know he did not, that the court had not issued a CPO in his case? The trial court found, and the record supports, that he knew he did not have a CPO case, because if you look at the transcript from March 19th, on page 26, the court explicitly says that the court says that I am dismissing your case in Chang v. Tomorrow. So he knew that he was there. He also had an attorney. If you look at the transcript, he had an attorney that was sitting with him that he could confer with. So he knew that he did not have a CPO when he walked out the door. He knew that his case was dismissed.
Ms.
And
Shepherd,
because-
thank you. Go ahead. Go ahead, please.
And because of the transcript and the record, the trial court made a finding that he knew, and that finding is supported by the record. And because of that, the finding is not clearly erroneous. Thank you.
Thank you, Ms. Shepherd. And if you want to submit the case that you mentioned, that will be fine.
Thank you.
Thank you. Let's go to Ms. Matheson, and we'll give you 2 minutes.
Thank you so much, Judge Thompson. I do just want to remind this court that although the appellate court requires deference, the review is de novo, and there's an obligation to take seriously the requirement the evidence in criminal prosecution must be strong enough that a trier of fact behaving rationally would find it persuasive and reasonable doubt. And in this case, as we've noted, there was a modification in March. There is some paper that is being passed back and forth. You can see that in the transcript. There's, as Judge Easterly mentioned, there's talk of printing it off, but then we do not have that modified order later. And although the court says in the hearing that the CPO against Ms. Tomorrow is being dismissed, it is also equally clear, especially in the voicemails to the prosecutor's office, that Mr. Chang does not understand that to be the case. He is not able to track what is happening at that hearing. And Mr. Cooper is actually the counsel sitting beside Mr. Chang during that hearing. He has not been appointed to Mr. Chang's case at that point. I believe he was appointed afterward. I also
I'm sorry, that point again, Mr. Cooper was sitting next to Mr. Chang, but had not been appointed. Is that what you said?
Yes, I believe he was advising him, but at that point, Mr. Chang was technically uncounseled. And then last, I just wanted to point out that the case that the government relies fairly heavily on, Inri Sobin, that's a case in which the defendant had reached out to the petitioner's attorneys specifically to relay a message to the petitioner. And that is not the case in this situation. In Mr. Chang's situation, he is not reaching out to police or the prosecutor to relay a message to Ms. Tomorrow. He is reaching out in an effort to prosecute, granted mistakenly, his own CPO against her. Thank you so much.
Thank you, Ms. Matheson. Thanks also to you, Ms. Shepherd. The case is submitted. Thank you. And our next case is number 19 PR 0636 in Re Estate of Christopher B. Powers, Nora Powers, appellant. And Mr. Hand, are you ready to proceed?
Yes, I am. Good morning. Mariah Harani prepared appellant's brief in this matter, and she's left the private practice of law to work for the government. So that's why I'm here. I'd like to have
Well, welcome.
Thank you very much. I'd like 2 minutes for rebuttal.
All right, please watch the clock.
With the court's indulgence, I'd like to start with a hypothetical that deals with part 1 of the brief, that the trial court's findings were clearly erroneous. Imagine a man in pioneer days. He lives with his wife and his children in a cabin on the frontier. Prior to leaving home for an extended period of time, he puts money, canned goods, and other provisions in a box, which he buries in his backyard. However, he forgets to tell his wife and children about the box. He leaves and he never returns. Now, can it be said that he adequately provided for his family? We submit that the answer clearly is no. The box doesn't do the family any good because they don't know it exists, because the father and husband never told them. But now, what if the container is discovered? Let's say the family dog sniffs it and digs it up, so the family gets access to it. Does that change the answer to the question? Or using a corollary from Fourth Amendment law, that a search is not made legal by what it turns up, are the frontier man's actions judged by what he did before he left home? And I think that's the issue before this court. There's 2 factual findings the court made that I want to quote. And, first is that Christopher Powers was content with his estate plan as it was at the time, and was not in a rush to create a new trust because he knew that he had mechanisms in place. The other finding was that Mr. Powers was aware at the time he drafted the December 2014 will that the Merrill Lynch IRA would pass through his estate and pour over into the revocable trust upon his death. Those are really the 2 key findings. And with all due respect to the court, there simply was absolutely no evidence that Mr. Powers knew that he had mechanisms in place to dispose of his estate, or that he was aware that the IRA would pass through his estate. That was
Mr. Hain, can I ask you a factual, while we're talking about factual findings and the facts, can I ask you a factual question about the 2014 will? I'm not sure whether you'll know the answer to this or whether the record reveals it, but so that will had a bunch of specific bequests, and then
Yes,
it creates a residuary estate.
right.
And a lot of the specific bequests might, depending on contingencies, have flowed over into the residuary estate. But do you know whether there were assets of the estate that weren't the subject of any bequest, and so they were kind of necessarily going to be part of the residuary estate? And if so, what the size of that was?
If there were any such items, they were not significant. I guess they might have been keepsakes, but but there were not any bank accounts or other things that would have gone into the residuary estate, as I recall.
Thank you. And I have a related question, I guess, and that factual question relates to the next question, just how to understand things. On your view of what the elder Mr. Powers' testamentary intent was, what's your theory about why Luke Powers was named the executor of the 2014 will?
Well, I think the record at the trial was that Christopher Powers did not want to burden his wife with that responsibility because he believed she would be too upset by his death.
Well, that may explain why he didn't want his current wife to do it, but I guess my question is it seems as though your view of the testamentary intent in 2014 is that if things went as the elder Mr. Powers wished, that 2014 will would not provide anything to the children of his first marriage, including Luke Powers. Is that right?
Well, our position is, yes and no. No, that he intended to provide for him, and but yes, our position is that the gift lapsed. Now, one thing that
and my own question is just seems a little incongruous to again, with respect to almost all of the estate assets, I guess, in your view, really none of them were going to, unless things went in an unforeseen way or not the ideal way. That's a better way of putting it, I think. Luke Powers was going to get nothing under the will, but he's made the beneficiary. That just seems a little incongruous. I mean, I made the personal representative.
Right, right. No, I understand the point, and let me answer that by saying that there's something the trial judge could have done, and that was, considered the fact that Andrew O'Connor, the stepson, was provided for in the will and would not have been provided for in the 1999 trust. The court could have imposed a constructive trust and said, all right, it's obvious, it's very, very clear that Christopher Powers considered Andrew O'Connor as his son and wanted him to benefit, and therefore he would be a beneficiary under the trust. Therefore, I'm going to use my equitable power to order the creation of a trust. Now, that's not the position we're advancing. We're advancing the position that the gift lapsed, but I think that the designation is Andrew O'Connor as a child. It's sort of the elephant in the room that that neither the trial judge nor Kelly in his brief convincingly addressed. I mean, it's obvious that that this stepson was intended to be a beneficiary, but then we move on. I'm sorry, Judge.
Yeah, I had a similar thought because the will defines the term children to include Andrew, but then I think makes no use of the term. You sort of ask yourself, why is that definition there if the only use of it is in that phrase for the benefit or FBO, children and grandchildren, and if you go to the 1999 trust, it doesn't include Andrew. Is there some other job that definition plays in the will that I missed?
Yeah, well, in the will, all of the bequests have a residuary beneficiary, and
right, this FBO trust is the
right.
residuary in a
Right.
number of provisions.
I see what you're saying.
But I'm saying, having defined the term children to include Andrew, does the will somehow use the term in a way that gives something to Andrew if he gets nothing through the 1999 trust? And it seems that he wouldn't without
would,
some
no,
sort of
no,
a
no, no,
constructive
he would.
trust.
No, he wouldn't, but he would be
Well, I thought he would. I thought he would if the, if the, depending on each of the bequests, there are a series of places to which the bequest might go if the initial intended recipient is unavailable to receive it. And the ultimate, in some of them, though not all of them, is the residuary estate. And if it had passed through everything else and went to the residuary estate, then it is defined in terms of the children.
right.
So in that sense, I thought the will did have operative terms that might have included the stepson or the child of his second wife. Depending on what contingencies had happened, most of them would have required that the FBO, the trust FBO children and grandchildren was not available to receive the bequest. But I'm not sure that's true for all of them. For example, like the 12th didn't skip, for whatever reason, the 12th bequest skipped over the trust FBO children and would have gone to the residuary estate if his then current wife, Ms. Nora Powers, had passed away first. So it depends, but it does seem like the residuary estate is defined in terms of children, which would include the child of Ms. Nora Powers' first marriage.
That's correct, Your Honor. That's correct. So now I'd like to get to why the trust fails. Any trust fails. In section 2, the appellant argues that the trust fails for lack of definiteness. Now, without saying in so many words, this implicates the doctrine of incorporation by reference, or the doctrine of independent significance, which apply when a will makes reference to another paper. Surprisingly, there's nothing in no cases I could find in the District of Columbia that dealt with this in the context of wills or trusts. But let me quote a Virginia case, Lawless versus Lawless, 47 Southeast 2nd, 431, 1948 case. There's a very thorough body of law in this. The restatement deals with it. These are the three prerequisites for the doctrine of independent significance. First, the extrinsic document must be a paper in actual existence at the date of the execution of the will. We have this here. The 1999 trust was a paper that was in existence. Second, it must appear from the face of the will that it is a paper in actual existence. And third, it must be identified and described with reasonable certainty in the will. We have neither of those two things happening here. Therefore, the trust bequest fails for lack of definitiveness.
Are you saying that almost sounds as though in the context of interpreting a will, if the will refers to another document and it's somewhat unclear what that document was, that you can't take extrinsic evidence? That's just impossible. You're not allowed to refer in a will to another document or, like a trust, unless the will itself, without regard to extrinsic evidence, makes it clear what you're referring to?
No, I think you could use extrinsic evidence to see if the outside document is the one that appears in the will. you know,
And I think that's what the trial court thought it was doing here. And so it seems like this argument kind of wraps back around to the question of whether the trial court correctly concluded from the extrinsic evidence that this is properly understood as a reference to the 1999 trust.
well, but there was just absolutely no evidence that he did. I mean, in the brief, the appellant says that he forgot about the will. I don't know if that's the best way of categorizing it. I think the better way to categorizing it is that Mr. Powers never gave the 1999 trust a thought. You know, whether he forgot about it or didn't think it applied, it's sort of besides the point. There's just no evidence that he thought he was referring to it, and that's what the trial court had to deal with. And if there's no other questions, I'll reserve.
Well, I think you're out of time, but we'll give you some time on rebuttal. Thank you,
Thank you.
Mr. Hand.
Thank you.
Ms. Edwards.
Good morning, Your Honors. Valerie Edwards on behalf of the appellee, the personal representative of the estate of Christopher Powers. And may it please the court. Your Honors, what has been appealed in this case is a very well-reasoned and well-supported memorandum opinion construing the self-drafted last will and testament of the late Christopher Powers. And as you know, it was to resolve this ambiguity regarding the identification of the intended beneficiary of the testator's IRA. And given this jurisdiction's strong constructional preference against disinheriting a line of descent, it bears noting that the appellant, who is the testator's second wife, has received all other assets of the estate under the will, valued at approximately $2 million. She's claiming through this appeal to be the rightful beneficiary of the sole remaining asset bequeathed to the testator's trust for the benefit of his children and grandchildren from his first marriage. Now, the appellant had the opportunity in the trial court to present all of her evidence at a bench trial before Judge Fisher. Following the bench trial, the judge invited the parties to submit post-trial briefs and propose findings of fact and conclusions of law. And he then issued a 14-page memorandum opinion discussing his consideration of each of the appellant's arguments and the facts presented. While the appellant may disagree with the court's ultimate conclusion that the testator intended to leave IRA to his trust, which it concluded was then in existence as a matter of law and fact for the benefit of his children and grandchildren, the appellant cannot point to a single fact or legal argument that the trial court failed to consider or properly address in its opinion. The problem with Mr. Hand's hypothetical is that there is evidence on the record that the testator did not wish for his second wife to learn of his estate planning intentions. The testator's financial planner had testified in trial that the testator was concerned about his wife's reaction, and so he did not wish to include her in any of the planning. So it certainly is not dispositive that he didn't tell her about the existence of the trust. And the record also shows that the nominated personal representative, his son Luke, didn't even know about the trust, and he hadn't seen a copy of the will. So just because he didn't have a copy of these things, and just because the financial planner Pamela Wise didn't have a copy of these documents, does not mean that they're not valid and should be given effect. I mean, the will itself was admitted to probate, so why shouldn't the trust be given effect? The record is clear that the trust was in existence. The best evidence on the record is that the testator, in choosing to say trust FBO children and grandchildren, and you have in certain instances the capitalization of the word children and the capitalization of the word grandchildren, which seems to indicate that there was some sort of an entity or instrument in existence that he is presumed to have intended to mean. I'd also like to address Judge Thompson's question about my children in this context and the definition of my children under the will. As an estate planning attorney with an estate planning practice, it's not unusual to acknowledge a person in a will without giving a dispositive bequest, just for reasons of affection. And I think that's probably what happened here is we have a relationship that formed after the trust was executed with this stepchild who was never adopted, and the testator acknowledged him as a child, but the bequest that was given to my children was the contingent beneficiary designation in the residuary clause. And the bequest to the IRA and as named, the beneficiary is named in these other specific bequests do not say trust FBO my children and grandchildren. It says trust FBO children and grandchildren. And this goes to Judge McLeese's question. None of the estate assets passed by the residuary clause. All of the testator's assets were disposed of by the specific bequests in the will. And this is a point that was acknowledged by the trial court in its opinion. And that's significant because the trial judge had recognized that the testator in this case made very intentional distributions. He was very aware of his estate and he had disposed of everything through a specific bequest. And he had a background with, numerous degrees and a very accomplished career. And so the trial judge gave credit to the testator being very intentional in his bequests. As for the alleged error of fact, the appellant argues that the trial court disregarded certain evidence presented at trial, and she outlined certain points of evidence she claims were disregarded in her brief. But the opinion reflects that each of these points were not disregarded. They were expressly addressed by the trial court and given weight as the finder of fact deemed appropriate. And so the appellant merely disputes the judge's interpretation of the facts, but she fails to show any implausibility or lack of support to meet the clearly erroneous standard as required to reverse the trial court's opinion under this court's holding in the Orshansky case. And the appellant also fails to establish any error of law based on the court's conclusions as to the law of lapse, its scope of the consideration of the extrinsic evidence in this case, or the revocation of the trust. And I heard Mr. Hand raise the issue of the doctrine of, pardon me one second, the doctrine of independent significance. And the reason why this does not apply here is because we have to apply Illinois law to the construction of the trust. And not just the construction, but whether or not it exists or it's been revoked, and any effect that we need to give it. And why the court needs to apply Illinois law is because this is directed by the choice of law provision. So in this case, there's absolutely no dispute that the trust was duly executed. That was never raised at the trial level. It shouldn't be raised now. I don't think that there's any dispute. The question is whether or not it was revoked. And the court found in this case that, as a matter of fact, that the testator never revoked the trust. In order to revoke the trust under its terms, I think it's section 2.2 of the trust, the testator would have to execute a written revocation, some sort of signed written document. The appellant in this case has suggested that the doctrine of implied revocation may apply based off of the marital settlement agreement, or the subsequent 2014 will could constitute a signed written revocation of the trust. And this just is inaccurate under Illinois law, which is different from the District of Columbia law in this case.
Can I ask you, Ms. Edwards, in your brief, you had, I think, argued with respect to the issue of revocation that issue had not been sort of presented properly in the trial court. You now seem to be saying that actually the trial court decided that question in your favor. And if the trial court did decide the issue in your favor, it seems like the issue, maybe the trial court shouldn't have decided it or should have, maybe it was adequately presented to the trial court or not, but if the trial court decided it, don't you agree that we therefore need to decide it also?
Well, Your Honor, the trial court, in making its ruling on this issue, actually acknowledged it was not raised by the appellant at the trial level. And so it was raised, I think it's record page A62, and the appellant, I believe, may have brought it up in, I don't recall the exact context, but the court acknowledged this, perhaps because we raised it. But the court said that the appellant didn't bring it up, but in any case, he decided that the trust had not been revoked under its
Well, my impression was that it was raised in the answer and in a pretrial conference. Then it's less clear that it was kind of presented during the actual litigation of the claim.
Correct.
And then the trial court does seem to the trial court makes a statement of law about the trust, I guess, which is in order to effectively revoke the trust, the provisions of the trust require a written signed revocation. That probably isn't disputed. That's what the trust says. And then the trial court goes on and says, evidence of revocation hasn't been presented or advanced by an argument. So I was just unsure whether the trial court decided it or didn't. But you were arguing today, I thought sort of contrary to your brief, that the trial court actually did decide the issue. And so that's why I was trying to clarify whether you think the trial court actually resolved the issue on the merits or whether you think the trial court instead said, well, the trust says something and I'm not going to address what the answer of the issue here because it hasn't been raised.
Well, I do appreciate the distinction, Your Honor, and I would say that in order to determine that the trust was in existence, the trial court had to somewhat make a determination that it was never revoked. The trial court, you're correct, did not address the issue of whether or not it was revoked by the arguments that are raised today in terms of the subsequent will or the marital settlement agreement having some sort of operation of law effect. And I would just say it doesn't matter because on the merits, this argument doesn't succeed. Under the Illinois law then in effect, the marital settlement agreement expressly by statute could not have revoked that trust because under the Illinois code, which is cited in my brief, the statute required that only those provisions that benefited the former spouse would be revoked as if she had predeceased, and that all other provisions of the trust would remain in effect. So under the Illinois code in effect at the time that is applicable to this case, there is no doctrine of implied revocation by the divorce. So on the merits, if the court does consider that issue, it is very well settled under Illinois law. Similarly, there is Illinois common law that is in effect, and it is the Lowry case that is cited in my opinion, or in my brief, that says very clearly under Illinois law, and this is where it does diverge from District of Columbia law, a later will needs to expressly revoke the prior trust in order to do that. A later will that only revokes a pour-over will does not have the effect of revoking the revocable trust because the trust is considered a distinct and independent entity, its own instrument under Illinois law. So that is the common law that applies to the later will. So this doctrine of implied revocation is not going to apply to this case.
I'm not.
No, go ahead, Judge Thompson. No, go ahead.
I was just going to, this is on a different point. So if you wanted to follow up, please do, Judge McLeese. I didn't understand your point, Ms. Edwards, about the capitalization used in the phrase trust FBO children and grandchildren. Could you explain that, please?
Yes, Your Honor. In the will, the definition has in the quotes, quote, my children, end quote. And so that is a phrase, and my children is used as a phrase only in one place in the will, and that is as the contingent residuary beneficiary. So if the appellant Nora Powers had predeceased the children as defined in the will, then those 4 children, and that would be inclusive of Andrew O'Connor, who was never adopted but was recognized as my children under the will, they would have shared the residuary bequest. But under all of the specific requests, the particular language chosen by the testator is trust FBO children and grandchildren. It does not say trust FBO my children and grandchildren. And in certain instances in the bequests, they may the words children and or the C of children and the G of grandchildren are capitalized, which indicates a proper noun. It indicates a more formal reference to the entire instrument being referred to as the trust FBO children and grandchildren, not trust FBO my children.
I see. The trust, and I don't have it open, so I may be wrong about this, but what I was going to say is that the 1999 trust provides for the grandchildren, I guess maybe I do have it wrong. How does it provide for the grandchildren? Does it provide for them specifically or only in the case where a parent has died, where one of the children has died?
One moment, if you'll allow me a moment to pull it up. so I can
I'm glad
reference
I'm not the only one who doesn't remember.
It is,
Yeah, my point was going to be that if it does not provide specifically for the grandchildren and simply substitutes them if a child has died, then it seems peculiar to refer to it as a trust for the children and grandchildren with a capital G. And I was going to ask for your response to that, but it could be that my premise is incorrect.
pardon me, just one moment. And if I can give a little bit of context to the bequest. At the time that the testator drafted this will, he was expecting his first grandchild. And I think as I'm looking up this provision to give you a more technical explanation of how the trust operates with regard to the grandchildren, I would say that in such a case, the law recognizes in the District of Columbia and in most jurisdictions that you do not need to give a description of a beneficiary with exact precision. And I believe it's the Knupp case in the opinion of this court in the Knupp versus the Columbia case, where the test is not whether or not a bequest lapses because it's not, the beneficiary is not identified with an exact precise term or name, but that you are allowed to consider extrinsic evidence to identify the proper beneficiary and create a fair inference of who was intended in that circumstance. And in this circumstance, it is very clear from the language that the testator wished to benefit his children from his first marriage. He was expecting a grandchild on the way. Whether or not he was giving a whole lot of thought to the actual evolution of the funds through the mechanisms of the trust when he drafted it is probably not the proper consideration for whether or not he intended this particular class of people to benefit through the trust provisions. And allow me.
Can I ask you a loose end? Judge Thompson, has that answered your question, or I don't mean to?
Well, I thought you were still looking for language, but
I am, Your Honor, but I'm going to continue to look, but I don't want to hold up. I can continue to look.
well, I suppose we can all look back at it after the argument, so I don't want to take our time for that. So please go ahead with your question, Judge McLeese.
So I just had a question about a loose end in the case that I found a little puzzling. We've been talking today at times about the 1999 trust, singular, but I understand that there's a 1999 revocable trust and a 1999 irrevocable trust. And I just had a couple questions about the 1999 irrevocable trust. First is that in the record somewhere? Do we have the 1999 irrevocable trust in the record? Is it in an appendix or?
Your Honor, I believe it was excluded from the appendix. There was never an argument made that the irrevocable trust was funded or ever put into effect, and there's a different threshold for the effect of an unfunded revocable trust under Illinois law than there is an unfunded irrevocable trust.
And the other trust was funded only with $5. Is that the distinction?
No, Your Honor. The irrevocable trust was intended to hold, I believe, life insurance proceeds, which was a completely distinct asset, rather than the irrevocable trust was originally executed to be a catch-all to the forever will for all of the assets of the estate.
So you're saying that what you're saying now isn't really in the record because we don't have, or is there references in the record to the reasoning why people weren't including the 1990 irrevocable trust in the record?
The irrevocable trust, Your Honor, it's not included in the appendix. It is in the record. It was admitted to evidence, if I'm not mistaken. But
okay.
There was no argument.
And I get your first point, if I understand it, which is it related to an asset that is different than the asset that is currently at issue. It was intended to hold an asset that is different from the asset that is at issue in this case. Am I understanding that point correctly?
Correct. It was.
Can I ask you a related? I got that, and I'm just curious whether. Do you know whether its distribution of that asset was structured in the same way as the distribution of the assets under the different assets under the, or more general assets under the 1999 revocable trust?
off the top of my head, I do not, because we did not make any argument that the irrevocable trust was the intended beneficiary. I can.
No, I know you didn't. The only reason there's kind of a passing thought in your opponent's argument that maybe I forget where I saw this, but at one point there seemed to be a passing suggestion that it was a separate problem with interpreting the 2014 will to be referring to, you know, a trust that was already in existence, because there were two 1999 trusts that were different and you wouldn't know what the reference was to. And so that kind of added to the ambiguity of the situation. And I just want to make sure I understood a couple of factual questions about it. But I know you were not making any affirmative argument that that was the proper holder of these assets. But your opponent did at least at one point kind of make a fleeting argument that it was a point that cut in her favor, at least to a degree.
Your Honor, I did see that point. It really, it was never raised at the trial. It was never raised post-trial. It was never something that was presented with the court. The only reason why the irrevocable trust was ever raised with the court is because it was as part of an entire estate planning package. And the entire estate planning package was admitted to evidence, or at least presented to the court. And again, there's a different threshold for giving effect to an irrevocable trust that in this case is intended for holding, I believe, life insurance proceeds. Then that is never funded and is never given effect. An irrevocable trust, for instance, would require a separate tax ID number. A revocable trust does not, because it passes through to the grantor, who uses his own social security number until he passes, and then that's a different story. So it really is apples and oranges comparing the irrevocable and the revocable trust under the arguments presented by the appellant, and it doesn't lend to their conclusion that creates any further confusion.
Right. Well, thank you, Ms. Edwards. Mr. Hand, we'll give you a couple of minutes. Oh, you're on mute.
Well, in addition to the issue of whether the trust was ever revoked, is the question of, did it ever live? Was it ever a, living, breathing organism? Really never funded. It was an empty vessel. It was intended to be a device that would be used in conjunction with the 1999 will. Of course, here the trial judge ordered that the 2014 will pour over into the 1999 trust, which we as previously argued, we think the judge was wrong. As far as the argument regarding the judge's intent to avoid disinheriting a line of descendants. I say this with the utmost respect for the court. I think the trial judge was engaging in rough justice in order to prevent that disinheritance from happening. And just like, I think, he engaged in rough justice and cutting out Andrew O'Connor. Appellee's counsel cited the Knupp case. That's Knupp with a K, which was cited in the appellant's brief. Just point out in that case, Judge Newman wrote a very interesting opinion, and in that case, it's not really relevant on the facts, but it was a case where everybody knew that the testator intended his estate to go to his friend, but it was just completely obvious that was the intent. But his lawyer made a drafting mistake, and as a result, the estate ended up escheating to the District of Columbia. And sheets are not favored in the law. However, it does show that form is very important in estate planning, and sometimes at the expense of substance. And that was the case here. Christopher Powers was as the court found, he was very savvy and very intelligent, but like a lot of intelligent and savvy people, his estate plan was defective. And as a result, the appellant, Nora Powers, should receive the benefit of the Merrill Lynch IRA through the residuary estate clause. Thank you.
Thank you, Mr. Hand. Thank you also, Ms. Edwards. This case is submitted.
Thank you.
Thank you.
And our next matter is number 18 CV 1271, Patrick Malone and Associates PC et al. Versus Estate of Myron H. Seltzer, Esquire et al. And Mr. Schneebaum, and I'm sorry if I mispronounced your name, please correct me.
Very well.
Proceed.
Thank you, Your Honors. So the appeal before the court now concerns the propriety of an award of summary judgment in the Superior Court in a case in which, by all accounts, material facts were in genuine issue. The underlying matter between the parties concerns an arrangement for the allocation of responsibilities and compensation for legal work to be done on a case that was pending before the Superior Court. And there was a document, a contract, a 2007 agreement in which the parties, these lawyers, allocated both the responsibility and the compensation that they were to receive. The interpretation of that contract below, which took no account of the facts, in fact, preempted any consideration of the facts, concluded in a vision of the agreement by which the attorney who actually did the work of trying the case and producing the result would be compensated less, and the attorneys who did not do the work and who had a lesser role in the trial that led to the judgment, that led to the settlement, were to be compensated more. Now, in a review of an award of summary judgment, of course, the court is to apply the same standard that the trial court was meant to apply, which is to say that the court should look at the evidence in the light most favorable to the non-moving party and affirm an award of summary judgment only if in that light there are no genuine issues of material fact and the movement is entitled to judgment as a matter of law. And
Mr. Schneebaum, let me interrupt you just for a moment, focusing on the facts in the light most favorable. I want to be sure that I have this correct. The jury in this case was not charged with determining amounts of money owed, damages. Their job was to determine liability, essentially. Is that correct?
That is essentially correct.
Right. And so it was after the trial that the court actually determined the amounts of money owing from Geico.
Correct.
That's also correct.
That is correct.
The facts also seem to be that while the trial was significant and obviously the finding of liability or none in the case of the emotional damages was significant, there was a great deal of post-trial briefing on the way to the dollar amounts that the judge determined. Correct? A lot of post-trial briefing. And it appears that Mr. Malone's role in the post-trial briefing was lesser than the role played by others, Mr. Seltzer and others. so on looking at the facts in that way, and looking at them in the light most favorably to Mr. Malone, and crediting his explanation about his devising the trial strategy and questioning most of the witnesses, et cetera, it's a little difficult to think that the outcome was incongruous with the degree of effort put out there by the different lawyers. I'm interested in hearing your response to that.
Well, my response to that, Your Honor, is that the judge below did not reach that question. The decision below was not founded on a factual determination that Mr. Selter did more work than Mr. Malone.
I do appreciate that. I understand that. But the way the case has been argued to us is that Mr. Malone has been injured because despite his great effort, he's not being compensated appropriately for it. So I'm just trying to get the big picture here, although I take your point that the court did not or found the language of the paragraph of the agreement, paragraph 15, I think, to be unambiguous.
Well,
so
that's
did
right.
not get into extrinsic evidence.
That's
I
right,
do understand that.
And the outline, if I may, if I may characterize it that way, that Your Honor just articulated, is an argument that presumably the Selter estate and Mr. Jaffe would be able to make before the jury. They would be able to say, well, look, it wasn't simply the trial. It was a whole package of other material that led to this. And looking at that as a whole, the jury might conclude that Mr. Malone was not the attorney in charge. But that isn't the issue before this court right now. The issue before the court right now is whether the interpretation of the contract as unambiguous precludes even reaching the question of who did the work. The judge
Can I ask you some questions about your view about what is ambiguous or unambiguous in paragraph 15? And I'll give you just as an example. Do you agree that it's unambiguous that paragraph 15 was intended to replace a regime in which the amount of fees for each of the lawyers would be determined by calculating exactly how much each of them did in connection with a particular claim?
No, Your Honor, we with respect do not agree with that. Had there been no paragraph 15, then each of the lawyers would have been paid fees depending on what his client received by way of damages in the case from a jury award.
I'm puzzled by your answer, so let me just give you a hypothetical. Imagine that this case had settled before the pretrial conference, and imagine that Mr. Malone had done nothing, and instead all the responsibility for all of the work up to that moment, the moment of settlement before the pretrial conference, was done instead by Mr. Selter and or Mr. Jaffe, who I know was primarily doing appellate stuff. Am I right? Do you think the contract unambiguously, the agreement unambiguously would nevertheless entitle Mr. Malone to 40% of the settlement?
If it turned out that Mr. Selter, as Your Honor has hypothesized, if Mr. Selter was in fact the active lawyer and Mr. Malone stayed home, then Mr. Selter would have been entitled to 60% of the fees and Mr. Malone 40%.
But the reason I give you that example is that doesn't that show that unambiguously, this provision is not trying to figure out and determine allocation based on who exactly did what. Because in that example, your client would have done nothing, but he'll still get 40% of the fees. What it was intended to do was to supplant a regime where there would have to be a very detailed inquiry into exactly who did what, with a predetermined ahead of time calculation that was maybe a rough guess about who would likely have done more when, but it was intended to supplant a fact specific inquiry into exactly who did what and try to tailor the apportionment of fees according to that. Do you agree with that or disagree with that?
No, Your Honor. In fact, we would suggest exactly the contrary to that, because had there been no paragraph 15, then the allocation of fees would have gone according to not to who did the work, but to who was entitled to charge.
I don't mean to hang you up with the word supplant, But do you think it's unambiguous that this provision is intended to divide fees in a way that is different from exactly who did what work?
No, again, with respect, our position is that this language imported into the contract the need to determine who did what work.
Well, I just thought you gave me an example. I thought you thought your client would be entitled to 40% if it settled pretrial, even if he did no work.
Correct. That because the contract provides that up until the time of pretrial, the fees are to be divided 60% to the attorney in charge and 40% to the other counsel. Regardless of how much or how little the other counsel did, if the attorney in charge was able to settle the case before pretrial, he or she or they would have acquired 60%. But the provision of Section 15 goes further than that. It says that the scaling up of the compensation from that point, from that 60-40 split to a 75-25 split, depends on who was the attorney in charge. Now,
that's certainly true in the broadest sense of who is in charge of the claim. But what in the language of the provision, in your view, permits, much less directs, the idea that the attorney in charge of the claim might fluctuate during the course of the litigation of the claim? Because it doesn't, I mean, the wording says attorney's in charge of the claim, and then it says, well, we're going to tie percentages to the stage of the proceeding. It doesn't say anything about, the attorney who was in charge of the claim at that point in the proceeding. So I'm just wondering where in the language you think it even permits, much less directs, an inquiry where the attorney in charge kind of fluctuates over time.
We point to the very use of the words "the attorney in charge" to entail that consequence. That is, had they meant to say the Athrage's counsel gets 75% if trial proceeds, they would have said so. If they wanted to say lead counsel, as defined in paragraph 10 of the agreement, gets 75%, they would have said so. Or if they wanted to say, as the court below held, that the attorney whose clients, quote unquote, own the claim gets 75%, they could have said that. But they didn't say that. They said the attorney in charge, and then they scaled the percentage to which the attorney in charge is entitled, depending upon milestones and developments with respect to the trial. Not the
Counsel, I have another question for you, which is about, I was a supervisor for many years. And so I was in charge of a lot of projects that I did very little work on. I did some, hopefully I didn't interfere with the actual work of folks who were doing the work. But being in charge of something and being the one who does most of the work seem to me to be quite different concepts.
Well, we accept that, Your Honor. It is certainly possible for someone to be in charge and not to do any work. I'm quite confident that does not describe, Your Honor, when you were a supervisor, but it is possible that one could do that. But in this case, we submit that the evidence will show that Mr. Malone's contribution was not simply that he put in more hours or burned more midnight oil. His contribution was that he was in charge. He directed the trial. He designed the trial strategy. He interviewed the witnesses. He prepared the exhibits. He did the exhibit notebooks. He did a test run with a model jury. He made the opening argument. He made the closing argument. But again, all of these are questions of fact.
I get that. And let me just ask you one other language question about paragraph 15.
Please.
Do you think paragraph 15 provides for a sliding scale for the Geico emotional damages claims?
Paragraph 15 does not say that it devises a sliding scale for the emotional damages claims. And that's, I'm glad Your Honor raised that. The emotional damages claims were owned by the Revises. They were not assigned to the Athrages. And yet paragraph 10 of the agreement says that the Athrages counsel will be lead counsel in the emotional damages claim. That immediately demonstrates.
I definitely get that point. I get that point for sure. I get the point you're about to make, but just to focus for a minute before you move off of it, move to it. You answer my question in part by saying it doesn't expressly say that there is a sliding scale created for those claims. But I just want to make sure, what's your position? Does with respect to those claims, does this provision implicitly or in some other way create a sliding scale that applies to them too? Or were
No.
those claims really not subject to a sliding scale, and they would have been subject to whatever pre-existing rights people might have had?
Yes, the latter, Your Honor, because there is no mention of the emotional damages claim in the context of paragraph 15. Since the Revises were entitled to 100% of any return on that claim, and of course there was none in the end, but they were entitled to 100% of it, Mr. Malone's fee would have been determined by his contingency agreement, engagement letter with the Rivas family. It was not subject to a sliding scale. Mr. Selter had nothing to do with the emotional damages claim as it was conducted. And in fact, both parties concede that point in their briefs. They both concede that the emotional damages claim belonged fully in all respects to the Attridges. And indeed, Mr. Jaffe makes a remark about, and Mr. Malone managed to lose that claim. Well, okay, the claim ended up with a zero return. But had there been a return, it would have gone to the Revises, and they would have paid Mr. Malone according to their agreement with their counsel.
I think Judge McLeese's question arises, at least in part, because paragraph 15 refers over and over again to the Geico assigned claims, but at one point on the third line on the top of page 6, it just refers to the Geico claims without the word assigned in there. And it causes one to wonder what's meant by that, since there's such careful use of the defined term before.
I noticed that too, Your Honor, but the term Geico claims is not defined in the agreement. The term Geico assigned claims is. The paragraph in which the emotional damages claims are discussed is not perhaps an example of brilliant, clear draftsmanship, but it does make it clear that any proceeds of the Geico, of the emotional damages claims would go to the Revises and not to a pool, not to be split. The Attridges would get nothing from that. However, the Geico assigned claims, which is to say the claims of the Revises had for that the Geico had behaved in bad faith in failing to pay the policy limits on the underlying lawsuit between the Revises and the Attridges. That claim was assigned, but it remained in the true sense, it remained the Revises claim. The Revises were the party with whom Geico had a contract. It was to the Revises that Geico owed a duty of care. And it was to the Revises that Geico defaulted in failing to make the payment on the policy. And so, and Mr. Selter referred to the claims that way before the jury. He referred to these as the Revises' bad faith claims against Geico, and that they were. Now, but
can I ask you another, just to get back to the question, the relationship that I find murky between being in charge of a claim and being the person who works on the claim. Imagine that there had been an express exchange of emails between the attorneys that had said, Mr. Malone, you're going to be the laboring oar for trial. You're gonna, you're the one who is gonna get up and do the witnesses and all of that. But make no mistake about it. This claim is, with respect to the Geico assigned claims, they're owned by my client, and and whatever decisions you make, you will need to clear with us. Any significant decision, we're in charge of the claim, and any decision you make will have to be cleared with us. And then there was an exchange back and forth, where Mr. Malone did 99% of the work, but he had these emails where he would check with the lawyer, Mr. Selter and the like, and they would say, yes, you have our permission to proceed as you wish. Go spend a lot of time doing all that work. Assume that those are the undisputed facts. Mm-hmm. Is it critical who did the work, or is it critical who had the sign-off authority and who gave the thumbs up or the thumbs down under this agreement?
It is the focus is on who is in charge, and that means who sets strategy, who makes the big decisions, and in trial context, that means who interviews the witnesses, who prepares the case, who identifies the exhibits.
Well, those examples seem to me, the different factors you're pointing to seem to me to point in different directions in my hypothetical. So I'm not sure how I understand to get an answer. Imagine that Mr. Malone did every single thing of those, everything, except on every big issue, he would check and get approval as required by Mr. Selter and or Mr. Jaffe.
All I can say to that, Your Honor, is that may be a close call. It would be a close call based on facts. It would require a
But I'm
jury,
just
a
trying to
fact
figure
finder.
out in law what it means to be in charge of a claim and how that relates in law to the idea of who did most of the work on the claim. And those seem to me, again, to be legally distinct concepts.
Indeed, Your Honor, that's perfectly acceptable to our side, but the dialogue that Your Honor and I have been having is a dialogue entirely based on and needing to be fleshed out by the kinds of hypotheticals that Judge McLeish just gave me.
Well, but no, I'm sorry to interrupt. I think we're just trying to interpret the language of paragraph 15, which doesn't refer to the lawyer that did the most of the work. It refers to the attorneys in charge. And
Indeed.
so we're trying to figure out what that language means,
Right.
or is
Exactly.
fairly interpreted to mean. And I think we're trying to figure out why you think attorneys in charge means the lawyers who did most of the work.
I don't say that.
Do you
Your
have
Honor.
any case law to
No,
support
I'm
that
not
interpretation?
arguing. I'm not arguing that Mr. Malone was in charge because he did the most work in the sense of he generated more paper or spent more hours. In fact, that's the other side's argument.
I thought that was your argument, that he was in charge at the trial because he did most of the trial work.
Our claim is that he was in charge at the trial because he ran the show, because he was in charge, because he made the key decisions, because he strategized, because he did the opening and he did the closing. There is no evidence in the record to suggest that any of those decisions were cleared with the Etheridges or with Mr. Selter or with Mr. Duffy, because they weren't. Mr. Malone was in charge of designing and conducting the trial, and he did so. But again, all that we are agreeing, I think, all of us, I think, are agreeing on now is that the term in charge is ambiguous.
Can I ask you, is it right then that essentially what you're saying is that the way the trial was conducted and the lead up to the trial was conducted was inconsistent with the statement in paragraph 10 that the Etheridges will have primary responsibility for major decisions in connection with the Geico assigned claims, including, presentation, and they will have the final say in all decisions relating to the claim. So it sounds like what you're saying is that although paragraph 10 seems to have contemplated something different, the parties sort of breached paragraph 10, and for whatever reason, the Etheridges and their lawyers kind of abdicated their responsibility and right under paragraph 10.
I think that's right. Our contention is that at the time that this document was drafted in 2007, it couldn't have been known how this whole matter was going to proceed. It couldn't have been known whether there would be a trial, much less what that trial would look like. So the original contemplation in 2007 may well have been that Mr. Selter would be in charge of all aspects, although of course it didn't say that. It said simply lead counsel in all aspects. Remember though that
no, but it does say, just to be fair, paragraph 10 says that the Etheridges and shall have the final say on all decisions. And if you're trying to figure out who's in charge of those claims from that provision, you would think it's the Etheridges and their lawyers, not someone else, because they're the ones who are in law given the final say. And so it's just a hypothetical again. If
Sure.
there's a statute which says, that places me in responsibility for something as a matter of my legal rights and responsibilities.
Mhm.
And, I say to one of my, somebody I'm supervising, you know what, you go ahead and do it. Don't bother me with any, don't bother me. Go ahead and do what you think is best. Don't, leave it alone. And that person goes off and does his or her best. It seems like someone might say to me later, if something went wrong, you were in charge of that. The law placed you in charge of it, and you did a terrible job of being in charge because you abdicated your legal duty to run it, but legally you were in charge. Do you think that's just not a reasonable way of talking about a situation like that?
It is a reasonable way to talk about the hypothetical that Your Honor posed, but we submit with respect that it's not a reasonable way of describing what actually happened here, because there is no evidence, and again, it's a question of evidence, but there is no evidence that in fact the Etheridge's lawyers were in charge in any respect of the trial. Mr. Malone ran the trial and all of its aspects. Now it's,
I guess the point is, one way of looking at it is your perspective is you should read the contract to figure out who factually was in charge.
yes,
And that could mean in part who did what work. It could mean who actually was kind of making the decisions and running the show.
yes,
The question I'm asking is another possible reading, and you could say it's ambiguous and therefore it shouldn't be a summary judgment issue, but I'm just floating that another possible different legal theory about what the attorney in charge means is the attorney who has a legal duty with respect to the claim. And so that's just a different reading. You're kind of reading in charge to mean factually in charge. And one could say, no, it means legally in charge under the agreement, who's legally in charge.
well, in theory, I suppose it could mean that, and we have two alternative readings, and the judge below introduced yet a third alternative reading of the term attorney in charge. But again, the case never went to the jury. Now, there are other issues that Your Honor's hypothetical raises. Paragraph 10 of the agreement, remember, was not signed by the lawyers. It was not part of the contract between the lawyers. It was an allocation of responsibility between the two families. And the two families may well have anticipated that as things played out, that Mr. Selter would be in charge of everything, and may have, but they also said that Mr. Selter would be lead counsel in the emotional damages claim. There's no question that he wasn't that. So why would the provision that he is lead counsel with respect to the GEICO assigned claims govern, while the provision that he was in charge of the emotional distress claims would somehow go by the board? In 2007, the parties could have locked this down. They could have said what Your Honor is suggesting. They could have said what Judge Rigsby suggested. They could have said, in other words, it doesn't matter who's lead counsel. It doesn't matter who does the work. It doesn't matter who's in charge. What matters is whose client, quote unquote, owns the claims. That was the basis of the decision below. That basis is, we submit, entirely unfounded in the record. If this provision of paragraph 15 is as ambiguous as this conversation suggests, then
I wonder if Judge Rigsby's interpretation, though, isn't fully consistent with the language of paragraph 15. As I first read paragraph 15, the natural reading to me entailed a focus on the word or, in charge of the Grimaldi claims or the GEICO assigned claims, with the or seeming to designate that we're talking about two groups of lawyers here, or two lawyers, one on each side. And one of them's going to get this and the other one's going to get that. And if one group of lawyers has its allocation increased, why then the other attorneys will have their allocation decreased. So while our discussion has been about what does in charge of mean and is it the same as owning the claims, it seems to me that the answer is in the word or. It's not talking about a case where it might turn out that Mr. Malone ends up being in charge of the Grimaldi claims and the GEICO assigned claims, because it means to draw a distinction between lawyers. That's all it does. This one goes up, that one goes down, or this one goes down, that one goes up. What's wrong with that interpretation?
What's wrong with the judges is that these claims were not on a seesaw. It wasn't that if one goes up, the other goes down. They were separate claims. The Grimaldi claims had not been assigned because they were malpractice claims, and malpractice claims cannot be assigned under District of Columbia law. The GEICO assigned claims were assigned to the Attridges with the understanding that there would be a sharing of any award. But again, it's not my job, I think, to suggest to Your Honor that your proposed reading is irrational or inconsistent with the document. It's simply to show that it is one of several consistent interpretations. Judge McLeese pointed to one. Your Honor, Judge Thompson has now pointed to another. Judge Rigsby had his. These are all, presumably, consistent readings of this ambiguous language. And since it is ambiguous language, the determination of the proper interpretation should have gone to the jury. And the other side didn't contest that below until they filed for summary judgment. They treated this like a factual dispute too. That's why they submitted 150 pages to the joint appendix trying to persuade the court that in fact Mr. Seltzer was in charge. Look at all the work he did. Look at all the hours he billed. Look at all the expenses he incurred. These are questions of fact. And the determination of who is the attorney in charge is a question of fact. It should not have been resolved as a matter of contract interpretation. And for that reason, we respectfully submit that the case should be remanded for further proceedings and ultimately for trial. Thank you.
Well, what's your thought on this point? I understand what you're saying, that you think there may be many reasonable interpretations and therefore there's ambiguity. But it seems more to me that the interpretation that you discussed with Judge McLeese and Judge Rigby's interpretation and my interpretation all lead to the same result. They all conclude that the language means that your client doesn't prevail on his theory. Doesn't that mean that in that sense, the language is not ambiguous? The choice of terminology may not have been as precise, and one can, differ a little bit on which phrase means what, but the net result seems to be that the reasonable interpretation and the only reasonable interpretation is the one advocated by your opponents. What's your response to that?
The response to that, Your Honor, is that question presupposes the determination of the very facts that are at issue. That is, Judge McLeese's questions, for example, focused on who actually did the work and what if the person in charge had delegated certain levels of responsibility and so on. Factual question. The question of whether that two-letter word or should be read as governing the interpretation of this provision, we suggest is also a question that should be put to a finder of fact. If there is an ambiguity here as to the meaning of the word or, it should be sorted out, not by a judge who did not rely on that provision, incidentally, did not adopt the suggestion that Your Honor made, but rather concluded something entirely different that the other side never argued in the court below, which is that the determination of who is in charge depends on, is a consequence of who owns the claims.
Can I ask you a hypothetical just to get, this is to follow up in a way on Judge Thompson's question, which is, if there are some uncertainties about how to read it, but if the proposal about that would favor your client to read it is not reasonable, then the other uncertainties may not help you. But let me just give you a hypothetical. Imagine that it was undisputed, it was expressed in an agreement between the two sides that that your client was in charge of the Geico assigned claims. That was said at the very beginning of this, and your client did all of the work all the way through pretrial conference. The trial started. Your client is still in charge, and then the day before the trial is supposed to end, your client has a medical issue and says, I can't continue. You're going to need Mr. Seltzer to be in charge of the trial for the rest of the trial. And, Mr. Seltzer says, sure. And Mr. Seltzer gets up, and there had already been, let's say, a settlement proposal, and there'd been back and forth. And Mr. Seltzer, is in charge for 10 minutes. And the litigant on the other side says, you know what, we want to settle. And so at the moment of settlement, Mr. Seltzer is the attorney in charge of the claim at that moment. But he'd only been it for a couple hours and had done very little. Am I right in understanding your view to be that the way to read the provision is that Mr. Seltzer would get 75% of the recovery and your client would get 25%? Because you have to figure out at the moment of settlement who was in charge and where it is in the process?
No, we would not agree with that, Your Honor, because the shifting of the fee entitlement to 75% begins when the trial begins. So anything, if Mr. Malone was in charge of all of the things that we claim he was in charge of, determining strategy, preparing witnesses, preparing exhibits, orchestrating everything, giving the opening statement, giving the closing argument, if he's in charge of all those things and suddenly has some medical misfortune immediately before he carries them out, he was still in charge.
Got it. So if that's your view, then a different hypothetical. Imagine that your client had been in charge of everything up to the 5 minutes before trial starts. And then all of a sudden he has a medical emergency and he says, oh my gosh, Mr. Seltzer, you need to step in and be the person in charge to take this to trial. And Mr. Seltzer says, I wanted an extension. And the trial court says continuance. And the trial court says, sorry, no. And Mr. Seltzer then, is the attorney in charge at the beginning of the trial, though he had done, nothing almost. You're saying that, at that moment, assume it settles, 15 minutes later, Mr. Seltzer would get 2/3 of the settlement and your client would get 1/3, because the moment is, there's a magic moment and it doesn't really matter who did what, except, as of that magic moment, who's in charge. Is that right?
No, again, Your Honor, our position is that a trial is not something that starts when the gavel falls and ends when the gavel falls. A trial is a process, and it involves strategizing and decision-making and orchestration and
But
preparation.
I thought,
of
I'm
various
sorry to
things.
cut you off. I thought the agreement in this instance defined what the beginning of trial was.
It does. It
Right, the
does.
beginning of trial, which shall be deemed to have occurred at the time the judge or the courtroom clerk calls the case to order for the beginning of trial. So I thought Judge McLeese was trying to structure a hypothetical that said 5 minutes before that moment in time,
No, I understand.
your
I think I
client has a
understand the
medical
question.
emergency and and Mr. Seltzer has to step in. And it seems like you're avoiding answering the hypothetical, which I guess we can take as an answer, but we'd appreciate an answer to the hypothetical.
Well, I'm not trying to avoid answering the hypothetical. To the contrary, I think that the question, if it's 5 minutes before or 10 minutes or a day or 3 days or 5 days, all of these raise questions as to who was in charge. And I think reasonable minds could differ.
So you're telling
under
us that we
certain-
should not look to the language that is in the agreement that defines, I think, with specificity when trial begins.
No, I'm saying
That too is also subject for interpretation. Is that
I'm
your argument?
saying that the language that defines when the trial begins does not say the person who is in charge at that precise moment in time.
And that's my problem. And that's my problem, because I thought your argument was that is the magic moment in advance. We were talking about other hypotheticals. It doesn't actually say anything about who's in charge when. It seems
That's
to
right.
suggest that there was going to be a single allocation of who was in charge. And all that's going to matter is when is it settled, and that'll tell you, it doesn't seem to contemplate shifting of who's in charge. I'm trying to figure out, on your theory, what determines when being in charge shifts, and what determines what that means for who gets compensated. And I'm having a hard time getting answers. So just again, on the exact hypothetical I gave you, attorney A has been in charge formally, practically every possible way you could think of, legally, every way, up until 5 minutes before trial. And then there is a clear understanding, no longer will that attorney be in charge. As of 5 minutes before trial, attorney B will be in charge. Trial starts with attorney B in charge, and then it settles soon thereafter. Who gets what percentage, on your view? A properly instructed jury, on your view, who should get which percentage of the fees that were generated through the of the recovery? The fees relating to the recovery up to that point. Who gets what?
Well, I think, Your Honor, that I cannot answer the question whether yes or no, or A or B, based on the facts as you've given them to me, because I think that there is a legitimate fact question as to what happened after the first attorney had the heart attack or came down with COVID or whatever it was that debilitated him, and the other attorney took over.
Okay, I'll give you a little bit more. That he accepted a previously offered, without spending more than 5 minutes on it, he accepted a previously extended settlement offer.
But was he in charge, or was he simply carrying out a strategy that was designed by someone else, planned?
Well, can I say that if you're unable to answer this question, it makes me very concerned that a jury would be able to answer it, which makes me very dubious that it is a reasonable way of interpreting a provision, because it seems like it's hard to understand who would recover what under the theory that you're advocating. And that seems, a downside. Whether it's enough to be, entitle your opponent to summary judgment, I don't know. But if I'm construing a document and one of the interpretations is, well, it's very hard to tell what it means in any given circumstance, that's a strike against it for sure, in my view.
Well, it is a vague term. Attorney in charge is not a term of art. Lead counsel is a term we all understand as lawyers. Attorney in charge, like anyone in charge, in the example that Judge McLeese gave earlier, where he's sitting in his office and has a case and assigns it to a young lawyer to handle, and he tells that young lawyer, now you're in charge. We need to know more. What does that mean? does that lawyer get all the strategic authority or not? Or does the lawyer need to come back and check with the boss to get the strategic authority? Was the lawyer handed a script to follow? Or was the lawyer told, wing it, go on your own way, do the best you can, and tell me when it's over? Those are the kinds of questions that would determine the interpretation of the attorney in charge. I'm not defending the use of that term as a paragon of clarity. It's not. But that's the very
It
point.
sounds like you're arguing that it's void for vagueness.
Or not void for vagueness, Your Honor, but certainly difficult to interpret. It is a vague term. And that's the argument we've been making all along. And again, the idea that that opponents below argued that lead counsel meant attorney in charge, the judge concluded that ownership of the claim determines who's in charge. We argue that actual work and strategizing and all those things determines who's in charge. That demonstrates the very point, which is that summary judgment in this case was inappropriate and the case should be remanded for trial.
Mr. Schneebaum, thank you. We'll
you,
give
Your
you a couple of minutes on rebuttal if you need them, but let's hear from your opponents. And I guess I need to hear first how you are planning to split your time. Who wants to speak?
It's Jack Hassett, Your Honor, on behalf of the estate of Myron Selter. I will speak first for about 7 or 8 minutes, and then Mr. Jaffe will speak, if that's
All right, thank
acceptable
you.
to
And
Your Honor.
as you've seen from the case of Mr. Schneebaum, sometimes 7 or 8 minutes grows into more time than that. So we shall see.
I've been
But
watching
please
the earlier, I was watching the earlier arguments too. And I want to
Can I
say that I
ask
think
Mr. Schneebaum to mute his microphone, please?
Your Honor, I think your questions and those of Judge McLee, crystallize our position precisely. And that is that what Mr. Schneebaum is doing is taking the 10 years worth of facts that occurred after the drafting and execution of the September 2007 agreement to somehow create an issue of fact as to what that agreement means. And it doesn't. In fact, Judge Rigsby said that the mere fact that the parties disagree on the interpretation doesn't create an issue of fact. And I would add, especially when the other party's interpretation is so far-fetched. I don't know if your honors have had an opportunity to look at the docket of the Geico case. It's 61 pages long, single-spaced, over 10 years. There was 4.5 years of pretrial. There wouldn't have been a trial if the various motions that Geico made to dismiss the case hadn't been defeated. And the jury
I
only...
understand that your opponent argues that's really a factual dispute that would have been better for a jury. But let me ask you a legal question that your opponent raises. And it's basically, the argument is that there's an aspect of the trial court's reasoning that is flatly incorrect, as I understand your opponent's argument, which is the trial court relied on the idea that attorney in charge equals attorney whose client owns the claim equals lead counsel. And the trial court thought all those things were the same. And your opponent argues that's just demonstrably false based on the settlement agreement, because with respect to the Geico emotional damages claim, the attorneys for the athletes are lead counsel for those claims, even though the Revises own those claims. And so in that respect, the trial court's reasoning is just got a mistake in it. Do you agree that the trial court's reasoning has that mistake in it?
Put that way, I would say to a degree, yes, because I think the idea of the lead counsel was that the Athridges wanted to make sure that their lawyer made the strategic decisions versus work, as Your Honor pointed out during your questioning of Mr. Schneebaum, making strategic decisions, some of which were enumerated in Section 10. They didn't want the tail wagging the dog, namely the emotional damages claim affecting their ability to litigate the GEICO assigned claims. The section 15 is the section that relates to the allocation and the division of the legal fees. And it says
Just
that.
I wanted to catch you up on your use of the phrase "to a degree," yes. I mean,
Well,
either that's mistaken in the trial court's ruling or it isn't. So
I
I'm
don't
not
think-
sure, you know,
I
about
don't think
73 degrees or something.
I don't think his characterization of lead counsel undermines the correctness of his decision that there's no ambiguity in section 15.
Got it.
And I
Okay.
would-
So I gather you're saying, yes, it had that mistake, but that's not fatal to summary judgment ruling.
Exactly.
You also, I thought, had made an argument at one point that it would be unethical to have the lead attorney, the attorney in charge of a claim, be someone other than the person. This is an argument that I thought you had made in your briefs, to have someone other than the person whose client owns the claim. And if your position is that's unethical, it seems to me that you have the problem that the agreement that your client signed expressly provides for it with respect to the GEICO emotional damages claims.
I don't believe that's true, because I think what they meant in that language when it says that the attorneys in charge of the Grimaldi claims or the GEICO assigned claims, as the case may be.
I'm focused on paragraph 10 now. And paragraph 10 seems to say, A, the Rivas's own the GEICO emotional damages claim, and B, the Athridge's lawyers will be lead counsel for that claim. And I thought the argument was made in your brief that providing those two things is, you can't do that. It's unethical to have attorney A, who's representing someone else, be the who owns a claim, be the lead counsel for that claim. So either you need to, retract the idea that that's just intrinsically unethical, or you need to acknowledge that your client signed an agreement that was unethical, or maybe a third thing, because I'm not understanding. But
No,
right now, your two options.
Right. I think I have a third option, and that is that they were analogizing this to like a class action, where you have multiple attorneys representing multiple claims and clients, but that for the sake of efficiency, one counsel is designated as the lead counsel as the sort of the tiebreaker. Okay. And I think that's what was meant by lead counsel in section.
So if
10.
this agreement had expressly assigned the authority, Mr. Malone as lead counsel for the GEICO assigned claims in this provision, if it had said that in paragraph 10, you would say that's not unethical, that would be fine.
Right. It's not, he wouldn't be representing it. He's the lead counsel only in terms of the decision-making for the management of the case, as we have in class actions, where you have.
Well, that
counsel
seems to
all
me
the time.
to be an acknowledgement that to the extent you were arguing that your opponent's interpretation would create ethical problems, it seems to me you're now acknowledging it wouldn't, because it's not really an ethical problem if under this provision, paragraph 10, lead counsel status was conferred on a lawyer who did not represent the party that owned the claim. Well,
our argument on the ethics was directed to the concept that Malone that a lawyer other than Mr. Selter could be in charge of the GEICO assigned claims any more than any lawyer other than Mr. Malone could be in charge of the the Grimaldi claims, because the claims belonged to the clients, to the respective clients.
So you think it's fine to be lead counsel, but not in charge. You can't be in charge. It's an ethical problem if you're in charge, but it's not an ethical problem if you are lead counsel for a claim that is owned by someone who's not your client.
No, I'm saying with respect to paragraph 15 on the allocation of the fees were being allocated according to who was the counsel responsible for the respective client's claims. And if you look at the division of the recovery and you look at the first arrangement of the fees, the 60-40, even before the case is started, in the Grimaldi case, the Grimaldis got 60% of the recovery and shared 40% with the Athridges. And in the Geico assigned claims, the Athridges got 60% and the Revises 40%. And I think what Your Honor was discussing before with Mr. Schneebaum in terms of when did these percentages change, Mr. Malone had the same understanding that it had nothing to do with the work because, and he put this email into evidence in February of 2012. He and Mr. Selter were preparing for trial, exchanging pretrial and jury instructions. And on the evening of February 24, I believe it is, he writes to he gives his comments on various papers and he says, attorney fee question. I forget the details, but we have some kind of sliding scale of attorney fee split as we get closer to trial. I believe I paid you guys full share on the Grimaldi settlement, and you might want to consider waiving this fee split change if you want me to participate substantially in the trial and in further pretrial work, just a thought. So he understood that under the terms of Section 15, once that jury was called, the split was going to go from 66 and 2/3 to 1/3 to 75 and 25. And Mr. Selter writes back to him the next day, on the split, the agreement is as of the pretrial, the split changes to 2/3 and 1/3. And as of the trial, it changes to 3/4 and 1/4. I do want your substantial participation at trial, so let me think about it. So what does this mean? It means that Mr. Malone understood that for the fee purposes of Section 15, Mr. Selter was the attorney charge of the Geico assigned claim. And that the split was going, and that they had to waive the provisions of Section 15, and that had to be in writing. And it never was. They never discussed it again. Not after the trial, not after 3 years of post-trial briefing, not after Judge Johnson entered a $15.6 million judgment, not in the year and a half that Mr. Selter was suffering from pancreatic cancer and yet working every single day up until the day he died. And they never raised it again until after he died. And my suggestion is that this email clearly demonstrates that Mr. Malone understood at the time that the fees didn't turn on who did what work, but who represented the respective clients, either in the Grimaldi litigation or in the Geico assigned litigation.
Well, thank you, Mr. Hasid. Did you have more points you wanted to make?
No, I think that covered it, and I'll let Mr. Jaffe.
Thank you, Mr. Jaffe.
Thank you, and may it please the court. I just want to go back to the question Judge McLeese asked and amend or correct something that Jack said. The judge below did not conflate the attorney in charge with lead counsel. He quite expressly on page 12, which is Joint Appendix 257, and page 13, Joint Appendix 258, accuses plaintiffs of having such a conflation and criticizes them for it, at which point he later says, while attorneys in, I'm quoting now, while attorneys in charge and lead counsel are differing yet related terms in the context of the agreement as a whole, he then goes on to explain why lead counsel corroborates how we treat attorney in charge. Because lead counsel is the coordinating counsel, not with exclusive responsibility, but with primary responsibility, but simultaneously with obligations to listen to the person who owns the coordinated claim. The whole reason for Section 10 was that there were two claims owned by two different parties that of necessity were going to be litigated together. somebody has to get up and talk first. Somebody has to not repeat what the other person says. And the party who had primary responsibility for making those calls was the lead counsel. But lead counsel could not settle a claim owned by the other party. We could not have settled the emotional damages claims without the Rivas making that decision. Whereas Malone, of course, could have settled those claims. So being in charge is, not surprisingly, exactly what the definitions of it say it is. It is the person having care or supervision of, or having control or custody, not the person who did the work. So if we had control and custody of the GEICO assigned claims, we certainly, average attorneys certainly did not have control over the emotional damages claims, but they did have a measure of control over the coordination within the trial. They are very different terms. The judge was not confused about this at all. And Mr. Schneebaum's suggestion that we never argue this is facially false. It is.
Can I ask you, Mr. Jaffe, you've addressed an aspect of whether the trial court was or was not confused, but let me ask you about the trial court's understanding of the connection between ownership and of the claim and attorney in charge. Do you agree or disagree that the trial court seemed to say that the attorney in charge will be the attorney for the party who owns the claim?
I agree, at my suggestion, no less.
And so who do you think was the attorney in charge of the GEICO emotional damages claim?
That would be Mr. Malone, without doubt. His client owned that claim. He was the attorney in charge of that claim. It wasn't relevant since we weren't sharing any of the fees, so it didn't matter in terms of fee allocation. But if the question is who was in charge of that, absolutely him. Only he, with client approval, could settle it, for example.
So your view is that the trial court, the trial court, the sentence that got me confused about all this, I guess, or that led me to think maybe the trial court was confused, is a plain reading of Section 15 in the context of the agreement as a whole, which includes the use of lead counsel to allocate responsibility in a joint suit and the ownership of the respective claims defined. And then he says the Rivas owned the claims, so the Rivas attorney were in charge. The Atheridges owned, so the Atheridges attorneys were in charge. I had interpreted that as the trial court believing that whoever's client owns the claim is the attorney in charge. But you don't think the trial court thought that or meant that?
No. Your second half was absolutely correct. It was the first half that talks about lead counsel that I think misunderstands what the trial court said about the relationship between paragraph 10 and paragraph 15. Paragraph 10 merely provides contextual evidence, intrinsic contextual evidence within the context of the overall agreement as to why our interpretation of paragraph 15 makes far more sense. And the reason why, of course, is that in paragraph 10, you see the notion of control not specified, but reflected in the notion of we get final say over something. Well, of course we get final say over our claims, but only over our claims and not over the claims retained by the Rivases, i.e. the emotional damages claims, which were not assigned to us, did not belong to my client, and thus we were not the attorneys in charge of those claims.
And do you agree also that the section paragraph 15 did not create a sliding scale for them? It just doesn't apply to them?
To the emotional
damages claims?
Absolutely, I agree. Of course. We had no claim on those recoveries. Had Malone won the emotional damages claim, his client would have got 100%, and he would have gotten 100% of whatever fees were allocated to that. Absolutely, unequivocally, there's nothing in paragraph 15 that applies to the emotional damages claims, because it was reserved by the Rivases, and there was no, remember, if you look intrinsically into the context, the whole reason this exists is because while the claims were assigned, Grimaldi to one client and GEICO assigned to the other, the recoveries were split 60-40. And therefore, since the attorneys could only get their fees from their own clients' recoveries, even if they did all the work on the claim, there was some notion of hedging one's bets, that if things ran on, if things went later, there would be a slight escalation from that baseline intrinsic 60% that you would have gotten no matter what, to a little bit more recognizing that you were the one in charge for years and years potentially, but you only got a piece of the action. So everyone agreed to hedge the bet. We both faced that risk equally and oppositely on two different claims. Malone faced that risk on the Grimaldi claims. We faced that risk on the Geico assigned claims, which is why you see this even-handed language, much like Judge Thompson noted, the or. It was designed to be, a seesaw might be the wrong phrase to it, but it was designed to be a symmetrical allocation of risk and reward, where they would get the potential upside on the claims their client owned, and we would get the potential upside. Now, all that is good background and interesting, but what I found fascinating about the discussion so far is how little it focused on the actual language of the agreement. So let's turn to the language of the agreement on section 15. The attorney in charge of what? That is the first and most obvious question that Mr. Schneebaum answers incorrectly. He continuously says the attorney in charge of the trial, yet that is not what the contract says. And this is precisely what the judge below recognized, that the attorney in charge is a status that extends before and through and all the way after to the very end. If the attorney in charge could change at a given moment, well, that would make no sense because that's not written into the contract. It says the claims, and claims pre-exist and post-exist a trial up until they're settled. Second of all, the word or, I just repeat what Judge Thompson said, that shows that our interpretation is perfectly consistent. His is not. If his interpretation was a proper interpretation, it would have said and or. So makes no sense, makes perfect sense in our construction. The other thing is the word after. So if you look at the timing language that says you will get the fees if the claim is resolved before this point, between these 2 points, or after that point. The timing refers to the resolution of the claims, not the performance of any given tasks. So it's not saying who was the lead counsel during the trial. It says when was the claim resolved? After the trial, before the trial, before the pretrial. So the word after suggests that his makes no sense, because otherwise, what if counsel shifted repeatedly after the start of trial, as even Malone's argument claims it did? He makes no claim at all that he was in charge once the trial stopped. Yet there were 3 years, therefore, where the Athridge attorneys, by his reading, were unequivocally in charge of the case. Well, if the answer is who was in charge when it settled, which was your question, Judge McLeese, well, then under his own reading, well, we were unequivocally in charge when it settled. The Athridge attorneys were plainly in charge. And he doesn't dispute that. He doesn't say otherwise. He says he was in charge for 2 weeks, maybe for a couple months if you want to count the pretrial stuff, over a 7-year, 8-year litigation. It's absurd on its face, which goes to the question that you had, Judge McLeese, about why would you consider an unreasonable and implausible alternative to create an ambiguity. Now, I'll talk about context and other things for a moment. I want to talk about 2 other things first. One is this notion of material issues in disputes. So there are lots of factual issues in this case. They are not material to the question before this court. The question before this court is not who was lead counsel. The question or who was counsel in charge, attorneys in charge. The question is, what does attorneys in charge mean? That is the question before this court. And all of this noise about I did more work, they did more work, I'm more important, they're more important, has nothing to do with the construction of the language. So either you accept the construction in the plain meaning with the definitions I've given, or you say it's ambiguous so I can look at extrinsic evidence as to meaning, not as to application, but as to what the words mean. And the only, literally the only extrinsic evidence in this case is the email Mr. Hassett referred to, which plainly agrees with our construction, that Mike Selter and I, well, he was at trial, but that the Athridge attorneys were in charge, because otherwise it makes no sense for Mr. Malone to ask that the escalator be waived. Because on his theory, the escalator was to his benefit, and he was just trying to get more money. But according to him, he already had the right to that. So it makes no sense. So even if you thought there was some latent ambiguity in this, you would turn to extrinsic evidence like the party's application of the language, like drafting history perhaps, which they cite none of, which if we have to go back, we'll cite a lot of it, but they cite none of it. It is their obligation to introduce that extrinsic evidence. And the only extrinsic evidence they introduced squarely contradicts their interpretation or construction of the language. So we have one construction that fits perfectly, that fits the language, that fits the concepts, and we have his construction, which he says is not fair. That is all he has, is he thinks it's not fair. So now the final things, I want to talk about your ethics question that you had to Mr. Hassad. The answer, I think, follows from my answer to the distinction between lead counsel and counsel in charge. If counsel in charge means what I think we've now admitted it means, which is the attorney who has supervision of, control, or custody of the claims, that attorney can only be the attorney for the client who owns those claims. And even assuming arguendo, you could bring another attorney in, that attorney would have to not have a conflict. They were not in charge of the GEICO assigned claims because they would have had to get a written conflict waiver, which never, ever would have happened. And we were not in charge of the emotional damages claims.
Actually, isn't the issue of conflict the same even if they're lead counsel?
No.
And assuming they are supposedly in the middle of, kind of jointly representing interests as, lead counsel, wouldn't you need to at least have a conversation with your client about possible conflict of interest and a waiver?
Well, absolutely. I agree that there is, but you want to know where that is? This whole settlement agreement. That is precisely why there is this detailed analysis of who goes first, who goes second, who gets the money, how do we resolve a disagreement about if there's a settlement, does it go to the emotional damages claims or does it go to the GEICO assigned claims? There is extensive disclosure, agreement, in writing by the clients, which could only be amended in writing by the clients. We dotted I's and crossed T's like anybody's business, precisely because it was a little unusual for enemies, former enemies, to be teaming up against GEICO, who now had the pot of money to satisfy the rest of our judgment and help reduce the cost to the Rivas's that they paid from having lost the case. So yes, there is an ethical issue. The difference is it was resolved. Under Mr. Schneebaum's theory, he admits that the clients all understood in 2007 that Malone would run the Grimaldi things and the Athridge attorneys would run the GEICO assigned claims. But things changed. Yet he not once shows anything to the clients that suggests, oh, by the way, that informed consent you gave is no longer really true. We're going to change that. Would you sign off on it? Not once. So if his theory is true, this contract would indeed be void. Under my theory, the contract is perfectly valid and respects every aspect of client autonomy and every aspect of client control. Malone could have gotten up and done literally everything at trial. And if that's what the Athridge attorneys and their clients decided was in their best interest, that would have been fine. We would have still been in charge. Even it's like the news reader on nightly news. The guy who reads the script may or may not be the person who wrote it. And the fact that Mr. Malone was the face of this story because we thought his clients might be more sympathetic in this moment, that's a strategic decision that indeed is part of lead counsel, and getting to decide may have primary responsibility over who talks and who does what. And that Mr. Malone added his thoughts and his strategy, great. He was obliged to do that anyway. He was obliged to do that because his own client had their own claim, which quite frankly overlapped almost word for word with our claim, except it had the emotional damages add-on top of it. He couldn't win his claim without us winning our claim. So the notion that you can disentangle the work that was done between those two claims is crazy. And that leads me to the last thing I just want to say is that it is so unreasonable. So the standard for what is a reasonable construction of a statute is what a reasonably prudent person would do. No sane lawyer would do what he suggested, is throw this to the mercies and the whims of a jury without even the barest effort to define how much work and how much input and for how much time made you the lead counsel. It's just chest thumping. So we go in front of a jury and say, I was better. And he'd say, no, I was better. And that would be how we would divide the attorney's fees. That is not reasonable. It is not prudent. And it's certainly not what the parties did. What the parties in fact did is when there was any variable that was important, like when does trial begin, they were quite specific about it. But the notion of who is in charge of a claim was not a variable, it was a constant. We were in charge of the Geico assigned claims, and they were in charge of the Grimaldi claims. And there was no need to discuss it because it was self-evident by what the word in charge means. So unless there are other questions, I would just refer you to my brief, which goes through the linguistic construction in some level of detail, goes through the contextual destruction and the parallelism, and explains why any alternative reading that would support Malone's case is unsupported by evidence and would destroy the contract and be unreasonable. The only extrinsic evidence, if you even imagine this was slightly ambiguous, supports us. He has introduced nothing going to the question of construction, only evidence going to the question of application, i.e., who should be considered lead counsel if you accept his view that lead counsel is work dependent. But you have to decide that question before getting to those other issues. If you don't think it's work dependent, all of his so-called factual issues are not material. There are indeed issues, and we take great difference with them, but they're not material to the question about what this contract means. And if it means what we say it means, what the judge below says it means, then those questions are completely irrelevant. If there are no further questions, I see I've spoken long enough, perhaps.
Thank you, Mr.
continue for more
Jaffe.
questions.
Yeah, I think the clock didn't move, but I'm sure your time is up. So let's go back to Mr. Schneebaum, and we'll give you 2 minutes.
Thank you, Your Honors. And very briefly, the one question that both Mr. Hasid and Mr. Jaffe avoid is the question why, if they were in charge all along, why did the percentage shift as trial got closer? And there's a reason for that. And lawyers know the reason for that. The reason for that was that the specific expertise and experience of trial counsel was going to be vital to this case. And we express no, and we imply no disrespect to Mr. Selter when we say he was not going to be the first chair in this jury trial. Mr. Malone took over in full view of everyone with Mr. Selter's consent. In fact, not only his consent, his ratification. He told the jury both in his opening and in his closing statements that he associated himself and his clients associated themselves with the arguments that Mr. Malone was making. And as a result of those arguments, the benefit that was generated went to the clients, of course, but also went to Mr. Jaffe and Mr. Selter.
Mr. Schneebaum, I want to give you a chance to respond directly to the point that both of your opponents made, the argument, which was as follows. There are a lot of facts being thrown around, is their argument. I'm paraphrasing it. But if we're focused on what evidence is there about what the phrase attorneys in charge means, the only extrinsic evidence was the email exchange, and that extrinsic evidence points against your client's view. So I want to, do you think there was other extrinsic evidence about what that phrase means, A, and B, either way, do you have some reading of that email exchange that supports rather than undermines your client's position?
Yes, we do, Your Honor. Answering the second question first, we do have a reading that undermines the argument that Mr. Jaffe made and Mr. Hasid made. And that is that trial was getting close, but it was still some time away. And the serious commitment of time that Mr. Malone knew he was going to have to make if he was going to be first chair had not yet been made. He needed to decide, is he going to take on this additional work? Is he going to take on this additional responsibility? And he wanted to clarify that. Now, he used the word waive. It's true. Perhaps you shouldn't have used the word waive. You should have used the word discuss, because it is certainly consistent with what he wrote to say to Mr. Selter, look, I know this case has been going on for a long time, and I know that you guys have put in a lot of work. I also know that as attorney in charge of this trial, if I end up playing that role, I would be entitled to a lot of money. Maybe we should talk about this. Let's come to an agreement. Let's settle. Let's sit down and talk like gentlemen. And incidentally, that unfortunately never happened. partly because, and we do have extrinsic evidence of this, I believe, partly because after the trial ended, because as Judge Thompson pointed out, there was not immediately a damages award, it made sense to put off that conversation until it was known how much money we're going to be talking about. And Mr. Malone will testify, if it comes to that he firmly believes that if Mr. Seltzer were alive today, this case would have been resolved. It would have been settled amicably between gentlemen, between friends, as they in fact were, despite the suggestion to the contrary from the other side. But I want to leave the court with this question. If it was known, as Mr. Jaffe says, who was in charge from the day in 2007 when that document was signed, and it was contemplated that there might be a trial, and that it was contemplated that the attorney in charge would not change, that is, the identity of the attorney in charge would not change, irrespective of who actually did the work, why did they key the fee escalation to trial-related milestones? It makes no sense, we submit, unless the purpose was to bring in a trial specialist and to pay him accordingly for the work that he would do. And that is what Pat Malone did. And as a result of that work, a benefit was generated for the Atheridges, for the Rebuses, for Mr. Seltzer, and for Mr. Jaffe. Our alternative argument, as the court is aware, there's obviously no time to go into it now, is a quantum merit argument. We respectfully direct the court's attention to our brief on that point. The judge below dismissed that argument simply because there was a written contract, as all parties agree. We suggest the law of the District of Columbia does not require that dismissal. But the bottom line is, as Mr. Jaffe sort of derisively said, it is fairness. It is about fairness. It is about fairness in making sure that the person who did the key work that led to the result is properly compensated. And that means that ultimately there are genuine issues of material fact, as both of those terms have been defined extensively by this court. And for that reason, the ambiguity of the term attorney in charge is a question of fact to be resolved by the fact finder. And this case should be remanded to Judge Rigsby with those instructions. Thank you, Your Honor.
Thank you, Mr. Schneebaum, and the court wishes to thank all counsel for their arguments. The case is submitted and the court is adjourned.
This honorable court is now adjourned.